Society applications for a coastal protection structure. We'll just introduce ourselves to you. My name is Rob Van Voorthausen. I'm an independent hearings commissioner based in Napier, and today I'm joined by
Amy Robinson, hearings commissioner based in Hamilton.
Morena, Shad Rolliston, based here in Tauranga.
And the first thing we're going to do this morning is have a health and safety briefing. Nancy.
Good morning, my name's Nancy Butler. You would have seen my name on all of your emails. I'm a consents officer here at Council. If you hear a loud siren, please exit the building the same way that you entered, and go to our evacuation place, which is where you parked your cars today. The toilets are as you walked in on the right, but just past the tea and coffee. On the left, if you're going out that way. The microphones, when you're speaking, just hit the right-hand side of the button at the bottom, and then that just hit that again to turn it off. If we can ask that you all turn your the sound off on your phones, Teams and laptops. If you haven't already done so, and you have any speaking notes that need to be circulated, can you get that to me as soon as you can or shortly after? Thank you.
Thank you, Nancy. So we've had a schedule circulated, which we'll proceed through today. But just before we hear from the applicant, Ms. Hill, if you could maybe just have the 42A reporting team introduce themselves to the hearing.
To my left is Bevan Hudson, who you all know, who's the reporting planner together with Anna Price. It's a joint effort, and Adam Davidson, the coastal engineer, and the rest of the council's experts will be available online as required.
Right, thanks very much for that. It's Mr. Slyfield, over to you. Just before you commence, just first of all, thank you to you and your team for circulating all the written material, which we've all three of us have diligently read. So nothing that's been pre-circulated needs to be read out loud to us because we've already read that, including the supplementary evidence that's come through reasonably recently from Mr. Fraser. But of course, everyone, including yourself, is very welcome to speak to that pre-circulated material, highlight key points. If any new information is going to be introduced today by way of table documents, we won't have read that. So we'd probably prefer for that to be read out loud if that happens. But otherwise, over to you to lead us through the case. Thank you.
Thank you. Morena Koto. My name is Morgan Slyfield. I'm legal counsel for Glen Isla Protection Society. And just by way of a quick introduction to the other personnel who are here, on my left is Mr. Faithful, who is giving planning evidence for the Society. To my right are Andrew and Lincoln Fraser, who are both members of the Society, and you're going to hear evidence from Andrew. In the back row behind me, we've got Mr. Davis, coastal process witness, Mr. Coombs, landscape architect, and Mr. Whitlock, noise expert. We will have others joining us throughout the course of the day to give their evidence. And perhaps just a couple of administrative matters before I move into legal submissions. I just wanted to make sure that we've all seen the same material. So thank you, Commissioner, for acknowledging the supplementary statements that came in. There were two of those from Mr. Boyd and Mr. Fraser. There's the additional simulation that has been provided by Mr. Coombs that came in on Friday. And I just wanted to note there was a set of draft conditions attached to my legal submissions. So hopefully you've seen all of that. One matter, and I don't think this is in any way an issue at all, but I just want on the record that Commissioner Rolliston has another role for Port of Tauranga, as I understand it, as an iwi liaison individual. And Mr. Faithful is doing work for Port of Tauranga as well, and they're both working on a project for Port of Tauranga. I don't think that gives rise to any conflict of interest, but I thought it would be better to have that openly stated in this forum so that everyone's clear about that. Now, with that said, you've got my written legal submissions, and on the basis that you've had that opportunity to pre-read, I'll endeavour to just take you through what are the key points. But given the nature of where we're at with a recommendation of decline from the council officers, I'm going to say that most of it is key points, but I'm going to endeavour not to read those to you as much as I possibly can. I think I won't go through the introduction other than to just comment on the points made at paragraph 3. There are a few matters that in my submission are fairly critical here. And right up front, the first one is that the proposal is not just for a wall. It is a combination of hard and soft protection. Second point is it has been designed to be outside of or landward of mean high water springs, so it's outside the CMA. And the applicant already has resource consent from the Regional Council for those activities that are inside the CMA. As you know, the structure will be almost entirely within reserve, owned by the Western Bay of Plenty District Council, and there's a small section on number 12 Glen Isla Place that will be on private land. And as landowner, the council has given in principle agreement to the project, subject to sorting out some conditions. The last point in that list, and I'm on page 3 of my subs, is that GIPS will cover the full costs of establishing the wall, the dune reshaping, and the replanting until it has successfully established. I think that's a point I want to emphasize because I don't think that's been well understood by some, or in fact many of the submitters. So moving on to the statutory framework, I don't think I will dwell long on this section. There are a couple of matters that are useful to highlight just as matters that will be of some importance to your decision making in my submission. The first is the point at 6A that conditions, in order to be valid, must be directly connected to an adverse effect of the activity on the environment. And I highlight that because, as I'll say later in the submissions, there are some conditions proposed by the council officers that I submit fall outside of that particular legal requirement. The next point probably to highlight is that there is this effectively a split under section 104, where on the one hand, one has an effects-based assessment, actual and potential effects on the environment, and on the other hand, one has consistency with objectives and policies or other provisions of the relevant planning framework. So dealing first with the actual and potential effects on the environment, it has a broad definition, and I've acknowledged at paragraph 11 that one of the consequences of that broad definition of effects here is that it is relevant to consider effects that may arise over time due to dynamic natural processes, including effects related to potential sea level rise. And I don't take it that there's any disagreement that that's the nature of the situation we're in. We do have to be very forward-looking in this context because we're dealing with effects that may not occur for 10, 20, 30 and longer years. At the foot of page 4, the panel must disregard any effect on a person who's given written approval, which in this case includes all of those members of GIPS at 9, 11, 12, 13, 14, 15 and 16 Glen Isla Place. And then we get to the second half of the assessment, which is the provisions of the relevant planning instruments. And the key point that I want to make just at the outset is the point in the second half of paragraph 13 that the purpose of those planning instruments is to flesh out what is in section 5, the sustainable management purpose of the Act, and the remainder of part 2 in a manner that is increasingly detailed both as to content and location. And you'll recognise that as a quote from the King Salmon decision, no doubt. The other point that is worth making here is at 14 that there is this hierarchy within the planning instruments, of course, which means that for present purposes, the regional policy statement, regional plans, the district plan must all give effect to the National Coastal Policy Statement. Coming on to effects, the potential effects of the project have been assessed for the society by a range of experts, and that's been summarised in the evidence that has already been filed. For many of the potential effects, they are agreed that the effects of the project can be adequately mitigated or are sufficiently minor so as to be reasonable or acceptable. And I've grouped them into some agreed and not agreed matters. So on construction, noise and vibration, there is broad agreement between the experts you're going to hear, both the applicants and the councils, that those matters can be adequately managed by conditions and will be compliant with district plan standards and, in the case of vibration, the overseas standard. On construction, transport and access effects, you've got some evidence on the table from the council from Ms. Brown that all transportation and access effects can be controlled and will be reasonable, and that's not contested by any party or expert, or at least not by any expert, I should say. Ecological effects have been assessed by Dr. Keesing and Dr. Bull for the society and by Mr. Shaw and Mr. Goldwater for the council. They all agree that effects can be managed to an acceptable level through appropriate conditions of consent. What they don't quite agree on is what those conditions need to cover, and I'll come back to that. Landscape, natural character and visual effects have been assessed by Mr. Kearns and Mr. Gumbley, and while their assessments differ, for present purposes, the most important point is that they both support the grant of consent. Coastal processes and hazards assessed by Mr. Davis, and his work peer reviewed by Mr. Clark for the society and by Mr. Davidson for the council. This is an area where we start to get into a little bit more of the complexity of the application, as you'll be aware. Regarding the northern end of the wall, that's the type 2 section, they all agree there will be no adverse effects on coastal processes following construction, given the northern end will be near permanently buried. Regarding the southern end, that's the type 1 section, they agree there is a need for the structure and the design is sound, but their views on the alignment and location differ. Effects on reserve and public access have been addressed by Mr. Watson on behalf of council as landowner. And the planners that you're going to hear from agree that effects on public access in the reserve will be appropriately managed by conditions. And then finally, in my submission, there are no cultural matters to address. So coming back in a little bit more detail to the matters of disagreement, the first of those, coastal process effects. Mr. Davidson, on behalf of the council, considers that the wall will have end wall effects on the reserve land to the south, and that these could be delayed by locating the wall further landward. He considers once the wall becomes exposed over time, it would cause localized beach lowering, and locating the wall further back landward would also delay this. It's not quite explicit, but his conclusion appears to be that he could support, I should say, the grant of consent for the southern section of the wall if it were located back against the private property boundaries. That's not an alternative that any of the other experts for the council have commented on. Mr. Davis, for the society, agrees that if the structure were located more landward, it would interact less with beach processes in the short term, but he disagrees there will be any end wall effects on land to the south until the beach significantly retreats, at which stage scour in the order of 2 to 5 meters landward and 5 to 15 meters shore parallel may occur. He considers this will only occur when there is significant storm damage to the whole of the dune front of the land to the south, and also that this will tend to repair by natural processes, as has been witnessed since the 2023 Gabrielle hail storm events. Mr. Davis also identifies some benefits in constructing the wall 5 meters off the boundary. Those being having a naturally planted area at the top of the wall will enhance the dune's natural recovery after storm events and may provide a meaningful backshore for other uses long into the future. Now, Mr. Davis, on the basis of those reasons, prefers that the wall is 5 meters off the boundary. He has considered how close it could be moved to the boundary, and in his view, it should be no closer than 1.5 meters to allow for construction and a minimum area of backshore for planting and or future access. That's an option that has then been put to each of the relevant witnesses for the applicant. And broadly speaking, Dr. Keesing, Mr. Coombs, Mr. Whitlock, whose evidence I've summarised under paragraph 25, say that they can support either option, but within their respective fields of expertise, they consider that locating the wall 5 meters off the boundary is preferable. Consistent with those expert views, GIPS maintains that a 5 meter offset from the boundary for the type 1 section of wall is appropriate, but should the panel conclude that a smaller offset down to 1.5 meters is preferable, and if council agrees to that as landowner, GIPS would accept that outcome. Coming on then to ecology, and I'm on page 9 of the written submissions if it helps the following. GIPS is going to rely on Dr. Keesing's and Dr. Bull's evidence on ecology. And there are really only 2 matters that I want to address in opening. The first is that Dr. Keesing considers the dune system to the south of the wall, that's the dock reserve land, has low value from an ecological standpoint and will rapidly rebound if disturbed. And in light of that, he does not support a condition requiring any form of mitigation on that land from GIPS. Secondly, Dr. Keesing does not support a condition requiring perpetual maintenance of vegetation on the dunes in the vicinity of the wall. He thinks that a condition that requires the vegetation to get to 80% or 2 years worth of maintenance after planting is sufficient. And at that stage, the obligation should come to an end. And I want to be clear here, I've referred at paragraph 29 to vegetation, but Dr. Keesing's objection to that particular proposal is not purely about vegetation. You'll recall there's a suggestion from the council's experts that there be a sand and vegetation management plan. Dr. Keesing's objection relates to both the sand maintenance and the vegetation aspects of that. In my submission, Dr. Keesing's position is consistent with the legal requirement in section 108AA for conditions to be directly connected to an adverse effect of the activity. On Dr. Keesing's evidence, a condition requiring revegetation of the dune land south of the wall cannot be justified, and in my submission it would be invalid. Likewise, a condition to maintain the vegetation that is to be restored following construction on the dunes in front of Glen Isla Place must have a time limit in order to avoid the same invalidity. Requiring the consent holder to maintain such planting in perpetuity would be to require the consent holder to mitigate effects that are not caused by the consented activity. The third topic in terms of this effects-based matters of disagreement is under landscape, natural character and visual amenity. There are 2 matters of disagreement here: how positive the landscape, natural character and visual amenity effects are, and whether a sand and vegetation management plan is required. In terms of the positive side of that equation, GIPS will rely on Mr. Coombs's evidence and will say that the positive effects, as he has assessed them, are one of the public benefits of the project. And that is, of course, a matter relevant to the application of Policy 27 of the National Coastal Policy Statement. As for Mr. Gumbley's support in relation to the sand and vegetation management plan, Mr. Coombs considers this as unnecessary. In his view, sand will accrete through natural processes if an erosion event occurs, as has been experienced since Gabrielle. And it is submitted this is consistent both with Dr. Keesing's evidence and the requirements in section 108AA. So in conclusion on the effects-based side of the assessment, it is submitted most of the effects-based matters are agreed. Those that are not agreed are readily capable of resolution, and the panel is likely going to be able to conclude that the project is appropriate for a grant of consent when considered in relation to its potential effects. The more significant difference of opinion really comes out of the second half of the Section 104 assessment, which is less to do with effects and more to do with the fit of the project with the policies of the applicable plans. Turning to that matter, the reporting officers have concluded that the proposal is inconsistent with the NZCPS, the Regional Coastal Environmental Plan, and the Regional Policy Statement, and Mr. Faithfull, as you know, disagrees with that. In my submission, there are three broad reasons why Mr. Faithfull's conclusion should be preferred as the more robust of the views. The first is an inconsistency point. The officers find that the proposal will be consistent with the objectives and policies of the district plan, including the particular objectives and policies regarding coastal hazards. They also acknowledge the plan has been reviewed specifically to give effect to the requirements of the NZCPS and RPS regarding coastal hazards. They proceed on the basis that the district plan has given effect to those requirements. As I've already mentioned, the planning hierarchy under the RMA moves from the general to the specific, and this means that a district plan properly formulated to give effect to the higher order instruments is the most detailed guide for any specific issue in any specific district. However, here the reporting officers have concluded that the proposal is inconsistent with the higher order framework, despite finding the project is consistent with the district framework that has given effect to that higher order framework. In my submission, that is contradictory. The reporting officer's conclusions cannot be reconciled unless it is suggested that the district plan has in fact failed to give effect to those higher order provisions, and that is the exact opposite of their explicit finding. Given that contradiction, I submit Mr. Faithfull's approach should be preferred. The second point to make on this subject is a question of weighting, because of course you'll be aware from the evidence that Mr. Faithfull comes to a different view about the meaning of the higher order provisions than have the Council's reporting officers. On this matter, I emphasise that the provisions of the NZCPS are expressed in deliberately different ways, and that those differences matter. As has been stated in the king salmon case, careful attention must be paid to the way those provisions are expressed. Those expressed in more directive terms will carry greater weight than those expressed in less directive terms. Of course, king salmon, as you all know, was concerned with policies that used the term avoid, and that was about as strong as it gets. For present purposes, by comparison, the focus is on provisions that provide guidance in relation to harbour protection structures, and I've listed those particular provisions. None of them is directive in the way that an avoidance policy is directive. On the contrary, the policies discourage harbour protection structures. They explicitly provide for harbour protection structures to be one option for assessment in areas of significant existing development. And I add that significant existing development is not defined in the NZCPS, but in the department's guidance, it's stated that significant existing development may include areas of residential development. If considering harbour protection, the policies state the assessment should recognise and consider the environmental and social costs, and the policies require that the evaluation should focus on approaches that reduce the need for harbour protection structures, and where harbour protection structures are necessary, their form and location should be designed to minimise adverse effects, and where they are necessary to protect private assets, they should not be located on public land unless there is a significant public benefit in doing so. To sum that up, while those policies establish some clear requirements that need to be satisfied, the existence of those requirements innately demonstrates that there are circumstances where hard protection structures can be permitted, consistent with the policies. In my submission, Mr. Faithful has carefully addressed each of those requirements, and relying where appropriate on the evidence of other experts, he has reached a robust conclusion that the proposal is consistent. Based on his evidence, it will be submitted that there are no other options for addressing the erosion hazard posed by storm cut, and that this means a hard protection structure is necessary. That addresses Mr. Davidson's view that there is no need or justification for at least some of the northern end of the wall, a view with which both Mr. Davis and Mr. Clark disagree. On that, Mr. Davis's evidence is that a storm cut in a 1% AEP event could extend well into private properties and threaten residential structures. So he supports building all of the wall now to address these risks. And both he and Mr. Clark consider it inappropriate to place reliance on the continued presence of the groins around 3 Mile Creek, given that is subject to the uncertainties of reconsenting. And I might add there, from a legal perspective, I endorse that approach. I think it's not appropriate to place any weight on the assumption that those groins will be reconsented. Related to that, it is understood that the district council is seeking or considering seeking consent from regional council for further sand push-ups. It's not yet known whether that application will be made or whether it will be granted. And even if it is granted, there is no reason to think that such push-ups would protect the Glen Isla dune and the properties behind it any better than the soft protection undertaken in 2010 and 2011, which lasted only a matter of weeks before it was entirely taken away by storms. The environmental and social costs of the proposed structure have been assessed in detail, and such costs have been found to be minor and/or acceptable. The form and location of the structure has been designed to minimize adverse effects on the coastal environment. And a key difference, as I ascertain it, between the applicant's position and that of council officers is that the applicant says there are, in fact, significant public benefits to locating the structure on public land. And those include protection of what council considers to be a strategic asset and what is recognized as a rare ecological environment in the regional planning, improved ecological outcomes from new planting, mitigation of erosion effects from 3 Mile Creek, better landscape, natural character, and visual amenity effects as a result, and securing the possibility of future access behind the wall. The third and final topic on this difference of opinion on the policies relates to a difference of view about managed retreat. The reporting officers seem to rely heavily on managed retreat as a concept in reaching their conclusion. And in my submission, the way they have approached that topic is not supported by the NZCPS and also does not reflect the reality of the consents that are in place on the various GIPS properties. Turning to the NZCPS, it requires managed retreat as one of the potential responses to address coastal hazard. And that's expressly stated in Objective 5, reflected in Policy 25C, and implicitly in the options-based assessment required by Policy 27. I submit none of that precludes the consideration of other potential responses or accords primacy to managed retreat over other options in a way that would make an alternative option inconsistent with those provisions. In fact, given the extensive guidance in the policies that explicitly address the possibility of hard protection structures, my submission is it cannot be that a hard protection structure is innately inconsistent with the NZCPS provisions regarding managed retreat. In the present case, a factor that seems to have been overlooked by the reporting officers or given very little weight is that this project in no way precludes managed retreat into the future as an option for reducing risk. The proposal does not introduce or expand any existing residential activity on the properties, and the possibility of managed retreat in the future remains an option. The proposal does not make that option any more difficult than it already is. And I wish to emphasize that it already is. I don't think there's going to be any debate in this room about some of the complexities and difficulties of moving to a managed retreat position. The second point is this reliance that the officers seem to place on the conditions that are on the consents on the relevant GIPS titles, and I won't take you through the matters quoted at paragraph 52, but effectively the officers say that all of the properties, or all but one of the properties, are already subject to conditions that require the existing dwellings to be removed or relocated, and that is disputed. The actual position is that only 3 of the properties have consents that make explicit provision for moving or removing structures when an identified trigger occurs. And contrary to the assertion that most or all but one require managed retreat, it is in fact only 3 of the 7 that have conditions of that sort. Further, what those conditions actually require is not relocation or removal of the entire dwellings on those 3 properties, but only the particular additions or alterations that are the subject of the specific consents. Those requirements are formalized in deeds of covenant that are registered on those 3 properties, and there are no other deeds of covenant or similar mechanisms on any of the other 4 properties that address managed retreat, and no firm managed retreat requirements on any of those properties. Now I'll pause there because I do have copies available here in hard form of all of those consents that have been referred to in Mr. Hudson's and Ms. Price's report. I've also included in that set copies of the 3 covenants that are on the 3 titles so that you have access to those. I'm very happy to take some time now to go through those at some level of detail, but I'm also happy just to table those if you'd like to look at them.
Yeah, there's no need to go through them. You can just table them. That's fine. We'll refer to them later if we need to. Thank you.
Thank you. Given the limitations I've just run through, it is submitted that the officers have relied more than is warranted on past conditions of consent. And in simple terms, it's submitted that those conditions do not mandate managed retreat in any comprehensive way. And in my submission, the more limited approach that is evident when one looks at those conditions reflects the legal difficulties that are inherent in forcing residents to relocate or abandon dwellings that have existing use rights. I note that in at least one decision of the Environment Court, the court has proceeded on the understanding that district councils lack the legal authority to remove such rights. That's the Awatara Riki Residents Incorporated case. I should note that is not that's a decision of the court on a consent order basis. So that wasn't a matter that was tested before the court or argued before the court, but that is a position that was, as I understand it, reached commonly between the parties to that consent order application and then recorded in the court's decision, but apparently with some endorsement. Ms. Hill is familiar with the case, having been counsel, I think, for one of the parties, and can no doubt shed some further light on that if need be. Further, none of the existing consents on any of the GIPS properties precludes any of the owners from taking other lawful steps to address erosion risks, such as by pursuing the present application. And as I've said, the proposal and managed retreat are not mutually exclusive. Among other things, the proposal addresses an immediate need to protect the properties and the reserve land itself from the severe risks of storm cut. In the absence of the proposal, the GIPS owners already face the risks of a storm cut so severe that it would entirely destroy the reserve land and threaten extensive areas of the private properties, including parts occupied by their homes. In my submission, the officers seem to treat managed retreat as if it will be something required at some time in the future. But unless effective measures are implemented now to protect the dune and the GIPS properties from existing risks, then the risks are not being addressed at all. What the proposal seeks to do is put in place an interim measure to ensure that existing coastal residences can continue to be occupied safely for at least the next 30 to 50 years, until such time as managed retreat may become the next course of action. So in conclusion on objectives and policies, for all of those reasons I've outlined and the additional reasons set out in Mr. Faithfull's detailed planning analysis, it is submitted that the proposal is consistent with both the higher order policies and the lower order policies regarding management of coastal hazards. And I turn next to a number of issues that have been raised through submissions and some through the officer's report. I emphasize that the fact that I'm responding to these does not indicate that I consider they are likely to be determinative of your evaluation. And there are some of these, given the experience of the panel, that I would not be raising, but for what I consider is an appropriate response being offered by an applicant to submitters' concerns. First matter is the council's in-principle agreement as landowner, which some submitters have raised complaint about. It is submitted that council's position as landowner is entirely distinct from its role as consent authority, and the allegations of breach of Local Government Act or any impropriety on council's part are just not matters that this panel has any jurisdiction over. As for the suggestion that formal agreement should be finalised before the consent is decided, that would also have been GIPS's preference, and GIPS has attempted to achieve that. But that has not been achieved, and as the project cannot be implemented until agreement is finalised, it is proposed that this is captured in the consent conditions, and I refer to draft condition 5. Landowner agreement is not strictly an RMA requirement, so this condition has been volunteered partly to respond to the submitter concern and is offered on an OGA basis. The next matter is term. GIPS has not sought a term of consent, but Mr. Watson has promoted the inclusion of a term in the consent. It's GIPS's understanding that this is primarily to address the duration for which the wall will be maintained into the future. It is unusual for a land use consent in a district jurisdiction to contain a term, and for the reasons set out in Mr. Fraser's evidence, GIPS considers the council's concern as landowner is better addressed outside the consent. There is ample scope for the formal agreement with council to cover duration in a way that ensures council can be relieved of any maintenance burden when the appropriate time comes. GIPS has proposed in its draft conditions that the agreement with council will require GIPS to assign the consent to council once the establishment works are completed, and subject to the terms of its final agreement with council, this means council would be able to surrender the consent at a time of its choosing. The next point raised is one from the submitters. They say the owners should accept the risk of being on the coast. GIPS does in fact accept the risk of being on the coast, but the submitters overlook that most of the owners bought their properties prior to 2011, when there was in fact a seawall in place. And some, like Mr. Fraser's family, were opposed to that seawall being replaced with soft dune enhancements. Having had the protection of a seawall formerly, and having had it replaced with soft dune enhancements which failed in short order, it is not unreasonable for the GIPS members to seek to restore some more reliable protection, especially when no material adverse effects will arise from the project and there will be public benefits, and it will be at GIPS's members' expense. The next point is that the wall will increase flood risk up 3 Mile Creek. This is raised by some submitters and has been considered and rejected by all 3 of the coastal process experts you will hear from. The next point is that there is no need for the wall on the basis that sand will naturally continue to accrete to the dunes. As addressed above, this fails to recognise that there is a present-day risk posed by storm events in the form of a significant storm cut. However, the submitter's recognition that sand naturally accretes to the dunes suggests the same submitters ought not to have any concerns about the effects of the wall because it will remain buried and out of sight. In other words, even if the absence of storms means the wall is never relied upon, the project will provide tangible benefits to the dune from native planting. There's a point raised about independence of experts, and I don't think I need to address that explicitly before this panel. I turn to precedent effects, which are raised by some submitters. Strictly speaking, a consent decision for one project cannot set a precedent for future applications, other than in the general sense that like cases should be treated alike in the interests of natural justice. However, of course, that principle relies on two cases being sufficiently alike to activate the principle. Consistency in decision-making is not inherently problematic unless the decisions being made are poor. And cases in which precedent has been treated as a legitimate consideration tend to relate to non-complying activities, where it is said that the granting of consent may undermine the very integrity of the relevant plan. Here we're dealing with a discretionary activity, not non-complying, one that has a lack of adverse effects and one that has positive outcomes. And it is submitted that precedent concerns in this circumstance should not influence the decision. There is a point raised by some submitters that the project misaligns or is at odds with GIPS's purpose as set out in its founding documents. The short response to that is the project is consistent with GIPS's constitution. And again, this is not a matter within the panel's jurisdiction to resolve in any event. The next point is around potential for damage to nearby properties, which you'll have ascertained is a key concern for particular residents. Those concerns, it is submitted, largely relate to work that was done on another seawall project in 2010 and 11, which allegedly caused property damage. And they do not reflect, those concerns do not reflect, firstly, that there are differences in the construction methodology between this project and that project, the 2010-2011 project. The concerns do not reflect that the testing that Mr. Whitlock has conducted using vehicles, materials, and methods similar or identical to those proposed have found noise and vibrations to be well within appropriate standards. And the agreement of Mr. Whitlock and Mr. Stiles that vibration will be at levels well below the level for cosmetic, let alone structural damage. A further safeguard is that there is a condition proposed that will require vibration monitoring when the work commences to ensure compliance with the standards is being achieved. And both GIPS and the contractor will have insurance to cover any unforeseen outcomes due to vibration. In all those circumstances, and in the absence of any expert evidence that contests Mr. Whitlock or Mr. Stiles' assessments, it is submitted there is no rational basis for the submitter's concerns. I won't dwell on the specifics raised by Mr. Fell, but I have addressed them in the written submissions at 85, 86, and 87. And of course, at 88, I record that you will hear evidence from Mr. Fraser addressing some of Mr. Fell's other assertions. Turning to maintenance costs, it is submitted that submitters have not understood the extent of the commitment GIPS is offering in terms of maintenance. GIPS has offered to cover the costs of maintenance. GIPS is already subject to a targeted rate that applies to all properties fronting the 2010 dune enhancement. GIPS is proposing that any costs to council for maintaining the structure or the planting that exceeds the amounts recovered by council under the targeted rate will be met by the members of GIPS. That is a matter that is subject to council's agreement, though GIPS cannot foresee any logical reason why the council would not agree to this. And just to be very clear about that, there's a distinction that I think it's understandable submitters may have missed between who carries the maintenance obligation versus who pays for the maintenance. And so here, in the longer term, the proposal is the obligation will sit with council as the owner of the land and in whom the wall will in fact be vested once it has been constructed and the vegetation has been re-established and so on, versus who's paying for it, because the offer is that GIPS will in fact cover all of the costs over and above those that are exceed the targeted rate. The next point is the need for a joint hearing with the regional council. I don't think I need to spend long on that. The simple point is GIPS says there's no need for that, nor is there any mechanism for that at this point in time. And in any event, this forum is an entirely ample opportunity for the issues associated with the project to be tested and evaluated thoroughly. The next point is that GIPS is said to have not consulted as much as it should have. In response, GIPS actively sought the views of all nearby residents and extended multiple invitations to engage with relevant iwi, hapu and marae, and engage with both the district and regional councils. It submitted GIPS took the responsible step of requesting full public notification, and that in all these steps, GIPS has acted entirely properly and discharged its obligations. In conclusion, you will hear evidence from the team of experts that you already have statements of evidence from, and I've listed them at the end of the submissions, and you will also hear evidence of a lay nature from Mr. Fraser. On the totality of that evidence, GIPS will contend that this consent should be granted subject to appropriate conditions. Now, I'm very happy to answer any questions you have in relation to those.
Yeah, thank you, Mr. Slyfield. That was a very fulsome summary of the submissions that we'd already read. Just like to remind all the presentations that follow, we have read the pre-circulated material. We have read it diligently. We may have questions for you, but there's no need to go through it in a lot of detail, but you're all very welcome to highlight key points for us. Now, I have a number of issues I'd like to explore with you, but before I do that, I'll just see if my colleagues have any questions for you.
I have a question about the duration of consent. So you were saying that it's not usual for a land use consent to have a duration. And this one, GIPS is proposing that they would be happy for a duration, but then it also says that once the consent is transferred to the council, that they would then surrender it. So I guess I'm trying to understand why a duration is required if it's going to be surrendered anyway.
Well, I hope I haven't confused you with that submission. Maybe I just need to go back over that a little bit. GIPS's position is that a term is not required in the consent. The agreement with the council is yet to be finalised, but it is proposed, obviously, that the wall, as you've said, would vest in the council. What then happens is, with the assignment of responsibility to council, becomes council's wall. Council becomes the consent holder. So all of the references to the consent holder and the consent are references to the council, not to GIPS. And it is council who has the legal right under the RMA to surrender consent. Now, GIPS isn't saying that council will surrender the consent, or that there will be a definitive moment in time when that might occur. And that's because where we are now, it's simply not realistic to imagine we can say with any precision, when is the time when this might no longer be an appropriate structure to be in this environment. All that the submission is saying is, once it's in council's ownership and council is the consent holder, then the council is in the driving seat because of that surrender allowance that exists under the Act. And that means if the council should decide, for whatever reason, at some future point, that it no longer wishes to have a maintenance obligation in respect of the structure, or that the structure is now having adverse effects that need to be addressed, council is not reliant on the normal suite of review provisions that a council must rely on in that circumstance, because council is in fact the consent holder and could surrender the consent, bringing the life of the consent to an end. The structure would then not be authorised legally, and the council could take steps to remove or rehabilitate or whatever it was that the council felt was the appropriate action to take at that point in time. So it's really just reflecting there is a practicality of the council owning the consent, owning the wall, that plays out a little bit differently here than it would in the ordinary course of events, and that is what takes away the need for a term to be expressed.
Sorry, I'm just trying to think this through. So then if they did choose to surrender it at some stage, they would, in effect, put themselves into some kind of potential for compliance issues because there's an unauthorised structure. And also, sorry, secondly, if they did also surrender the consent and we had ongoing maintenance conditions, then there would be no ongoing maintenance requirements. So I feel like there's a gap there for me in terms of what happens in the long term if the consent gets surrendered.
Well, so the 2 points there are the maintenance point and becoming unlawful. I don't make the submission lightly about surrender. I'm not suggesting that that's the first thing that council might do. And I acknowledge that once surrendered, if the wall is still there and the council has surrendered the consent, then the wall becomes unlawful overnight. I dare say there are ways in which the council could approach that issue by putting in place a plan for the wall's removal and surrendering the consent hand in hand, such that any period of unlawfulness is actually addressed. In terms of maintenance, it's effectively the same thing. The GIP's position is that there would be something agreed with the council in the separate landowner agreement that it has in terms of how long the wall might be in place. But that is the more appropriate place for it to sit, because if we put it as a term into the resource consent, then when that term expires, you have to renew the resource consent. We don't know, sitting here today, that the resource consent will have effectively become defunct because of the wall being exposed or no longer functioning the way it should, or whatever reason, in 20, 30, 40, 50 years. We can't pinpoint what that period of time is. So rather than have a term in the consent that requires you to come back and renew a consent at that point in time, if we put that period into the side agreement with the council, then it's open for that to be renegotiated with the council based on the realities of the situation at that time. So if the side agreement says council agrees that it will maintain this for example, 30 years, then in 30 years' time, you can have another conversation between the council and between the then owners of the GIP's properties about, is the wall continuing to function as it was intended to do? Is it having adverse effects that are different from the adverse effects that were consented, etc.? If it's functioning the way it was intended to, if it's not giving rise to adverse effects that are different from those anticipated in this forum, then it's possible for that maintenance obligation to be agreed to be extended without having to come back and seek another resource consent.
Okay, thank you. So I have one last question. Do we have the ability to impose conditions requiring certain matters to be included in the agreement between council and the property owners?
Well, the short answer is, if they are for the purpose of managing adverse effects, then yes, or with the applicant's agreement. You know, those are really the two inroads you have under Section 108 AA.
It would only be the latter, wouldn't it? We can't impose conditions on a third party.
Unless it's volunteered by
Unless it's volunteered. That's why I said that's only your last statement would be correct, not the first, I think.
Yep. Thank you.
Thank you. Thank you for the submissions. Just thinking about the inconsistencies, I suppose, in terms of approach between the council planners and the applicant's planners around how we treat other higher order policies, particularly the NZ CPS. And for the panel, just wanting to get an idea about how we, or some guidance from you about how we should treat that, thinking about the statutory planning hierarchy.
Well, I think there's no disagreement that you do need to have regard to all of those provisions. So I don't think there's a difference in terms of the view you're getting on either side of the room about the relevance of needing to look at those documents. We're not saying just because we are consistent with the district plan, you don't need to go and look at the NZCPS, for example. We accept the NZCPS is an important document. It needs to be looked at. It does set that higher order framework. I think what the key difference is, as I see it, and I've endeavoured to cover some of this in the submissions, there are probably a couple of key things there. One is you have competing interpretations between the council's planners and Mr. Faithful about the meaning of those higher order provisions. And the fundamental difference between them is at its most extreme, the council officers seem to treat the provisions as if they are a stronger barrier to hard protection structures than Mr. Faithful says they are. And in my legal submission, Mr. Faithful's interpretation is supported, and I've taken you through the way those provisions are structured, the fact that they provide for options assessments, the fact that, yes, they do have statements within them that are requiring a much higher degree of rigor when it comes to hard protection structures. But it's a degree of rigor that is all driven by that word discourage, not avoid. So we're just not in that space that other decision makers are in, where you have a policy that says, here's an outcome that you can't possibly allow to occur. Rather, you have to be satisfied that there's been sufficient rigor, and having applied that sufficient rigor, a conclusion is able to be reached that's supported by the evidence as a robust one and favourable to the grant of consent. So there's that side of things. The other side of the difference of view is how much emphasis or weight you put on the concept of managed retreat. I've been through that, fairly carefully, and the essence there is that for the society, I say that there is not something in place already that addresses the problem, and I think that's a fundamental difference of view between where the society sits and the advice you're getting from the planning officers for the council, because they seem to be putting a great deal of reliance in my submission on the idea that there is something in place. And so that's something that you need to look at carefully. But in my submission, when you go through the copies of the documents that I can provide to you that I'm going to table, you'll see that the provisions are as I've described them, that they don't actually provide for managed retreat in nearly the same way, in nearly as comprehensive a way as has been suggested. And in any event, even if they did, none of that precludes an application being made for this project in the interim. So I think those are the key differences as I see them.
Slifer, I just wanted to turn, first of all, you mentioned very briefly at the start of your submissions the consent that's already been granted by the Regional Council for this proposal. And you said verbally that it relates to activities carried out in the coastal marine area. That's not quite correct, is it? Because it also deals with vegetation clearance and earthworks inside the coastal environment outside of the coastal marine area.
Correct.
Now, an issue for me is that in previous hearings where there's been two consent authorities involved, including in this region and including this district council, decision-making panels have gone to extreme lengths to avoid the duplication of conditions, so that we don't have similarly worded conditions in a district consent and a regional consent, because all that does creates compliance uncertainty and creates chaos in terms of administering the consent going forward. The most recent case I personally was involved with was chairing the hearings for Te Puna Industrial Limited in the Te Puna Business Park, where our decision-making panel went to extreme lengths to avoid that duplication with the support of the applicant and both sets of reporting officers. So I think it's only fair to you and to Ms. Hill to put you on notice that should we be minded to grant consent, I would need a considerable degree of persuasion to come around to the point of view that conditions should be duplicated. So that any conditions that are in the regional council consent that comprehensively deal with issues that have been put before us in terms of this application, I can see no merit in duplicating those in the district council consent, should district council consent be granted. And I don't wish you to respond to that now. I just wanted to put you on notice. I think that's fair, and that's an issue you may want to talk to your planner about and certainly address in reply. And Ms. Hill, also be interested in your view on that. I'd be surprised if there's an inconsistent view coming from you, given that there was a very clear view coming through into Te Puna Industrial Limited in that regard. Just turning also to the regional council consent, it's been granted on the assumption or a condition that the wall will be located 5 metres from the property boundary. So a question for you is, if we were minded to decide on the evidence in this case that the wall should be located 1.5 metres from the property boundary, where does that leave the applicant in terms of its regional council consent?
It's a good question. It's one that I'd want to discuss with Mr. Faithful before I offered you an answer.
Yeah. I imagine there's an opportunity under 127 to seek change in conditions.
Yeah.
Or is it 128? I always get them confused, but the applicant can seek a change in conditions.
Yes.
So that's one avenue, I suppose, that the applicant would have to undertake. So you'll come back to us and reply on that as well?
I will, thank you.
Yep. So now just a couple, 2 or 3 specific matters. Just turn to your submissions. Yeah, maybe if you turn to paragraph 31.
Yes.
And you talk about a temporal limit on maintaining vegetation. Again, just looking at the regional council consent, that seeks a maintenance period of 2 years post completion of the planting or once 60% coverage of Indigenous species has occurred. Is that the similar sort of thing that you'd be seeking in this regard?
Yes, the only difference is that we've actually offered 80% in the district consent, but 2 years is the same.
Yeah. Okay. I think it's around about paragraph 66. You don't need to turn to it, but I think you talked about the consent being assigned to the district council. I assume you meant it would be formally transferred to the district council.
Yes, that's exactly right.
Yes. And at that stage, the district council would become responsible for any maintenance. And as you've explained, however, this applicant has agreed to fund that maintenance. So
that's right.
That's correct. Yep.
Yes.
Just stepping back a bit again, paragraph 55, you talk about the district council lacking the legal ability to remove existing use rights. Just for your information, I chaired the hearing at first instance for the Matata debris flow and the managed retreat that was enforced upon those landowners, or not enforced, but well, it was enforced on some of them. And that was a joint process involving Whakatane District Council and the Regional Council, for the sole purpose being that only the Regional Council in its rules could extinguish existing use rights. And that's why that was a joint process. So I guess I'm just agreeing with you there, but giving you a bit of background about.
Thank you. I appreciate that.
One. And you had a discussion with my colleague about surrendering the consent. And I guess my question for you is just how relevant is that for us as a decision-making matter in any case? I mean, I'm not sure it's appropriate for us to speculate on whether or not the district council may choose to surrender its consent in the future, should it accept the vesting or the transfer of that, the vesting of the wall and the transfer of that consent. That may or may not decide to do that. But in any case, that's not an automatic process under section 138(2), the consent authority. So the district council wearing its regulatory hat could refuse to accept the surrender if it thought that it would affect the integrity of the consent, the ability of the consent holder to meet other conditions, or would lead to an adverse effect on the environment. So even if in the future, should the district council as consent holder wish to surrender the consent, it's not a fait accompli. It has to run through a process, and there's no surety that the surrender would be accepted. Is that correct?
That is correct. And just on your point about asking you to be speculative, I entirely agree. It's an entirely speculative exercise. And I think the point that deserves to be made there is, so is the setting of a term. If the setting of a term is to deal with when will the life of the wall, no longer serve its purpose, because we're speculating about when that period will be reached. So I don't think there's an easy answer to any of that. And the essence of the submission I'm advancing is that in that context where it's speculative either way, the better place for there to be something concrete is in the agreement with council as landowner, because that allows a little bit more flexibility to come back and say, well, is it still working? Do we need to do anything about it, etc.? Whereas if it's locked into the resource consent, then everyone's back in this room again whenever that period runs out.
And lastly, just in terms of the issue of duration, the regional council consent was imposed for a duration of 10 years. What would be your submission to us should anyone in this process suggest that we should adopt a similar duration?
Well, the 10 years is self-evidently because that's a period that is ample to cover the construction of the wall. So if anyone were to suggest that that was appropriate for this consent, the answer would be it simply is not. And I think you can tell from the amount of investment that's been put into this and that the wall itself would require that it simply wouldn't stack up to do that if the term was ultimately as small as that.
Thank you. That's right. I just wanted to get that on the record, but thank you for that. All right, that's the end of our questions for you. So now we can proceed to hear from your witnesses, please.
Very good. Thank you. And just coming back, Mr. Chair, to your observation, you may be pleased to hear that unlike me, all of the witnesses have a very brief executive summary that they will talk to. And that has been put into a written form so that you needn't take notes. Those haven't been distributed in advance, I apologise, but they do all have a 1 or 2 page, or in some cases on planning, it's 4 or 5 pages that they will use to give you the highlights of their presentations.
Yeah, it would be good if they could be emailed to us through our hearing administrator, because we're modern people and we tend to work on screens rather than bits of paper. So it'd be nice to have them on our screens and we can follow them on our screens as the witnesses. So maybe during morning tea time,
yes,
they could be emailed.
Certainly, we can do that at morning tea time, so that you've got copies of them all electronically.
Yeah.
And in the meantime, we'll run off some. We'll use hard copies.
So anyone that we're going to hear from before morning tea would appreciate the hard copies. They can be emailed to us later, but anything we're going to hear after morning tea, if we could have the emailed version, that would be great. Thank you.
Thank you. So the first witness for GIPS is Mr. Fraser.
Yes.
I'm not intending to be overly formal in terms of the way I introduce anyone.
No need for that.
But you've had his statement of evidence, and hopefully now you've got his very succinct summary in front of you to take you through.
Well, good morning, Mr. Fraser, and welcome. And thank you very much again for your pre-circulated evidence. It was very clearly written, so we didn't have any trouble understanding that, but we look forward to hearing your summary this morning.
Thank you. Tēnā koutou. My name is Andrew Fraser. I'm here to give evidence on behalf of the Glen Isla Protection Society, GIPS. Thank you for hearing our application. GIPS has proposed that a buried rock revetment seawall be constructed in the reserve land at Glen Isla Place, which would protect part of the remaining reserve and the waterfront properties. When 5 out of the 7 waterfront property owners at Glen Isla Place properties were acquired by their current owners, including when my family bought 16 Glen Isla Place, there was an existing seawall in front of Glen Isla Place that had been constructed in 1983. The existing seawall was around 20 metres seaward of our private boundary. The existing seawall was removed in 2011 at the time that soft engineering in the form of dune enhancement was carried out at Glen Isla Place, which involved additional sand and planting. The dune enhancement failed almost immediately during a storm, since that time, without any protection, a substantial amount, 12 to 15 metres of the dune and reserve land has been lost to coastal erosion. During the Hale and Gabrielle storms in early 2023, several metres of reserve land was eroded, and today only about 4 to 5 metres of reserve land remains at the southern end of Glen Isla Place between the front of the dune and the private boundaries. Concerned about the risk of further erosion, particularly from storms, the waterfront property owners sought specialist advice on erosion risks and protection measures. The advice was that erosion is likely to continue and storm cut at Glen Isla Place could be 18 metres or more. That amount of storm cut would cause significant damage to our properties and our homes. Furthermore, we were advised that storm cut at Glen Isla Place could be further exacerbated by the proximity of 3 Mile Creek, as during large storm events, the outflow of water can scour sand and lower the sea bottom near the creek mouth, allowing larger waves near the shore and greater erosive energy to impact on the dunes. This was apparent from the Gabrielle storm when greater erosion occurred adjacent to the creek than further away from their outlet. In addition, the groins are only consented until 2032, with no certainty that the consent will be renewed, and without the groins, the erosion risk would be even worse. 3 Mile Creek is important to reduce flooding risk for the wider Waihi Beach community, as it works as an outflow for floodwater during large storm events, but it has an effect on our properties. GIPS was advised that it would be appropriate to implement coastal protection for the properties at Glen Isla Place. GIPS's expert advisors assessed the options, and it was determined that a buried rock revetment seawall located on the reserve land would be the best option because it provides effective backstop protection, it is durable and proven, and the effects are negligible and can be managed through conditions. The proposal also includes enhancement of the dune and extensive native planting to significantly improve the ecological quality of the reserve land. The location was chosen for reasons that include the following. It protects much of the remaining reserve land, which will have value in ecological terms and for its own sake as an asset of the council and hence the community. New Zealanders value the importance of the King's Chain, what used to be called the Queen's Chain, where public land is preserved between private land and the waterfront. To retain the option to provide future emergency and public access to and along the waterfront. To retain dune plants that can help naturally replenish the sand covering the wall after a storm. And because it is appropriate for the wall to be on reserve land, given it mitigates the effects of 3 Mile Creek. GIPS would prefer the wall to be in the proposed location, which is 5 metres from the private boundaries at the southern end of the wall, and that outcome would maximise the public benefits of the proposal. If necessary, GIPS would accept the wall being closer to the private boundaries at the southern end if that is the preferred outcome by the commissioners and acceptable to the council as landowner. But GIPS believes it should be at least 1.5 metres from the private boundaries to preserve enough of the benefits just mentioned. GIPS is appreciative of the support it has received from the council as landowner. Council has agreed to allow the wall on the reserve land subject to certain conditions, including the granting of this resource consent. The Section 42A Officers Report seems to recommend managed retreat for Glen Isla Place rather than coastal protection works, despite the finding that the effects of the seawall are less than minor and can be adequately managed through conditions. That seems a very harsh conclusion. In my statement of evidence, I have provided some information showing how damaging managed retreat is to the lives and well-being of those whose properties are affected, in addition to the economic cost of destroying perfectly good homes, and how it is not an appropriate solution where there is a viable engineering solution to the risk and where the solution has negligible effects. I cannot believe many people would recommend managed retreat for their own property when a viable engineering solution with negligible effects and with public benefits exists. In addition, as Mr. Slyfield has addressed, it appears that the recommendation for managed retreat is based on an incorrect understanding of the existing resource consents on the properties owned by GIPS members, and managed retreat does not address the risk of storm cut. The Coastal Engineering Review attached to Section 42A Officers Report recognises that the southern section of the wall is justified and the design is appropriate. But the report questions whether the northern section is needed, although acknowledging it will have negligible effects. GIPS believes that all of the wall should be built because storm cut could also affect the properties behind the northern section of the wall. The northern section is the most exposed to the additional risks arising from the proximity to 3 Mile Creek. Some amount of the northern section will be needed to manage end of wall effect during large storm events, and how much will depend on how big the storms are. There is no more logical end point for the wall at the northern end than the location that is proposed. With sea level rise, the risks are likely to further increase in the future, and given it has no effects, building it now as part of this consent is the most efficient and practical option with the least disruption to the dune. I know that there has been some opposition to our proposal from 28 submitters who, like us, value and care about Waihi Beach. We feel that we have gone to great lengths to minimise any effects of the project, and based on the assessment of our experts, with which council's planners agree, the effects will all be so low that they are negligible to minor and can be managed through appropriate conditions. The project has a number of public benefits. We are paying all the costs, including for maintenance. We face the risk of potential storm cut of 18 metres or more, which threatens our homes because the previous seawall was removed rather than being repaired or replaced. We ask for understanding as we seek to protect our homes, just as those who face other serious risks like flooding try to do what they can to protect their homes.
Thank you, Mr. Fraser. That's a very helpful summary. I'll just see if we have questions for you, Chair.
Thank you. Thank you for your submission. Just thinking about the removal of the previous seawall back in 2011, I have seen some material about when that was constructed. Given the issues faced by that seawall back in 2011, what's the prospect of issues happening to a similar degree in regards to this proposal?
The seawall that was built in 1983 was made of steel and timber, and it was a vertical seawall. And over the years, it deteriorated.
Excuse me. Can you please speak into your microphone?
Sorry.
Yeah,
Sorry.
that's okay. Yeah, we're live streaming, so.
Thank you. So that earlier seawall was made of steel and timber. It was vertical, and it deteriorated over time because it wasn't maintained, I'd say. Whereas the seawall we're proposing, firstly, it's much further back, be buried most of the time, and it's a sloping rock wall that's much more robust, and we would expect to last for decades.
I do have a question, but I'm not sure if you're the right person to ask. It was about the King's chain. I thought that that wasn't a thing anymore, but maybe I'm wrong. It's just interested in what, if that still applies.
I mean, I'm not an expert on it, but I think that it's that in New Zealand, traditionally, when land has been subdivided near beaches and things, that there has been a reserve of Crown land or publicly owned land generally. Obviously, there are exceptions to that, but I'm aware of recent subdivisions where it was a condition to cede an esplanade strip against watercourses and things like that. So I think it's something that's valued and appreciated and almost expected in New Zealand, but not universally adhered to.
That's certainly my understanding. There's no such thing as what used to be called the Queen's Chain. It's a bit of a misnomer. Upon subdivision, esplanade reserve or esplanade strips can be set aside, and there's no continuous King's Chain along watercourses in New Zealand. That's just a myth. Right, Mr. Fraser, I've just got a couple of questions for you. The first one comes from your primary pre-circulated statement, excuse me, of evidence. You don't need to turn to it, but at paragraph 424, you talk about the agreement you've been negotiating with the council, and you say it's been close to being finalised. Is there any update for us on that?
There's no update since I wrote that brief of evidence, the statement of evidence. We've had drafts that have passed backwards and forwards. At the last draft, there were only a couple of issues to be resolved, and so that's why we say it's close to being agreed, in the sense that there weren't very many matters to be discussed, but it hasn't progressed further in the last few weeks.
And if you're able to say, what were those couple of issues that were still being discussed?
Well, it's related to the term. I mean, that's the key issue.
Right. And I'll ask the district council this when we hear from them tomorrow, but what's your understanding of their desired term? Have they expressed a number to you?
I know that Mr. Watson, in his memo as part of the officer's report, stated 30 years.
Yeah.
But yes, but our view is that if it's managed in the agreement, then that can be, it could be either a term of 30 years, or it could be a right to cancel from the council's side after 30 years.
Yeah. And just one question from your summary that you tabled today. At paragraph 7, you say, GIPS. Is everyone calling it GIPS today? Or
we are.
GIPS. GIPS was advised that it would be appropriate. Who was that advice from?
Sorry, I'm just looking at which sentence that is. Oh, yes. Primarily Mr. Davis, who was involved very early on in the in this process with us.
All right, thank you, Ms. Fraser, and it's the end of our questions here, but thank you very much for your assistance this morning. We appreciate it. It's Mr. Slyfield. It's almost 10:30, 7 minutes off. Should we take a morning tea break now, which will give your team time to do some emailing to our hearings administrator?
That would be very sensible, sir.
Yeah, and the schedule has us returning at 10:45, so should we aim for that? Right, so we'll adjourn now and we'll return at 10:45, where we'll continue hearing the applicant's witnesses.
Thank you.
Closing the hearing. So Mr. Slyfield will just check their inboxes. We can't see anything in there.
Nancy's just left the room. I have emailed them direct to Nancy.
Okay.
But the next witness in any event is Mr. Boyd.
Yes.
There is no summary statement.
Yes.
You'll be aware that his statement of evidence is mercifully brief.
Yes.
He's also given that very brief supplementary on Friday.
Yes.
The intention with Mr. Boyd, unlike the others, is that he hasn't prepared to present anything. He's
Right.
simply being made available to you to answer any questions that you might have about the existing papers he's already filed.
Oh, that's excellent. Thank you. So he's, yeah,
This is Mr. Boyd on there.
Good morning. All right. Well, thank you very much for your written material. We've read that. I'll just see if we have questions for you.
Okay.
Good morning. The only question I had was about the rock. So one of the submitters is saying that he didn't think that weathered andesite was the appropriate rock to use for a structure such as this. So I was just wondering if you had any experience with other walls and how the rock has performed in those other walls.
Yeah, well, the main wall at Waihi Beach, most of that rock came from the beach quarry, as well as a couple of other quarries. All our rocks all tested into a very high spec. These days they have to be. We've done different, we've done walls like same as this in and around Waihi Beach before. So yeah, we've had no problems.
So no cracking or?
No,
Yeah,
no.
okay. Thank you.
Well, they all get tested. The rocks get tested and spotted as you bring them, before you bring them down anyway. So you only get the higher grade as you're building.
Thank you. Just one question. In terms of your construction methodology, if the works identified greater ground disturbance than what was indicated, would you commit to adjusting your methodology to suit?
Yeah, if we need to. Yeah, I'm pretty confident in the methodology that we've got. That'll work, but there's always learning and there's always new ways and different ways of doing stuff too.
Thank you. That was my only question.
Thank you, Mr. Boyd. No questions from me, but Mr. Fraser, I got a question for you that I forgot to ask you. So apologies for that. Yesterday on a site visit, we stood outside. There's a new fence in front of number 12, isn't there?
Yes, that's correct.
Yes, and we were just wondering how far seaward from that fence is the legal boundary of the property? Do you know off the top of your head?
Yeah, the only information I have on that is that yesterday I had a look at that wall as well, and I noticed that standing in the corner of 14 Glen Isla Place, I saw the fence and about, I guess it was a couple of inches to the on the seaward side, there was a peg that said boundary on it. So, and I know that Mr. Basin told me that he had it surveyed before constructing that wall. So I think he's built it relatively close to the boundary.
Mr. Slyfield, maybe if in reply we could have that confirmed. The reason for the question is that yesterday we were just putting it in our minds, if we go 1.5 meters out, where is that from the boundary? And if we're 5 meters out, where is that? But then we didn't know where the boundary was. So
Yes.
we were guessing a little bit, but if we knew what the distance was from that black fence to where the boundary is, then that would put our site visit into context.
And I think we're talking about the fence at number 12. That's right, isn't it? Yes, thank you. Very good. Then that concludes Mr. Boyd's part in the hearing. And the next witness is Dr. Bull, who you'll recall is joining us online. I'm hopeful that she is with us and that you've had in advance the summary statement that was submitted along with my legal submissions last week.
Yes. Yes, so we do have that already, don't we? So good morning, Dr. Bull. Can you hear us?
I can, thank you.
And we can see and hear you loud and clear, so thank you very much for that. Thank you for your evidence and your pre-circulated material. And as council has just outlined, we received a summary document from you that came in at the same time as the legal submission. So we're happy for you to just lead us through your summary document if that's how you'd like to proceed.
Yep, that's great. Thank you. I'll just go straight to the bullet point too. I think everyone knows why we're here. So the creek mouth and beach provide foraging and roosting habitat for a number of coastal shorebirds. In addition, northern New Zealand dotterel have been recorded breeding unsuccessfully at this location on 2 occasions, and those being in 2021-22 breeding season and also 2022 and 23. As such, the design, construction method and reinstatement works associated with the proposed coastal erosion protection at Glen Isla Place seeks to avoid both direct and indirect impacts on avifauna, including northern New Zealand dotterel and other shorebird species. Now, there were 3 main matters that were raised and submitted, and I'll just talk to my response in the next 3 sections. The first of the matters was in regard to the significant adverse effects on birds. It's my opinion that the proposal will not result in adverse effects on avifauna, including dotterel, due to the following. The habitat loss will be limited to the defined construction area, which does not include any habitat of potential nesting value to dotterels or other seabirds, shorebirds. Effects within the defined construction area will be limited to the period of construction. The completed construction will result in the replanting of the area behind the existing northern spinifex dune and native dune vegetation, which will provide higher quality habitat for northern New Zealand dotterel chicks than the existing exotic vegetation. Undertaking construction activities during the non-breeding season if possible. If construction activities occur during the breeding season, a pre-work survey must be undertaken so that the appropriate mitigation measures can be implemented to avoid disturbance, mortality and/or injury to nesting birds. Site visit outside the breeding season. While the site visit I undertook was outside of the breeding season, the assessment acknowledges that the northern New Zealand dotterel have bred adjacent to 3 Mile Creek mouth. As such, I've taken a conservative approach whereby I have assumed that it is possible for dotterels or other shorebirds to breed there, and hence the avoidance of direct impacts of the project in this area. A lack of recognition of the importance of the fore-dune area as dotterel breeding ground. The northern spinifex fore-dune is considered to be of high ecological value and has been avoided, and it is this area that may be used by dotterel chicks should birds breed there. In summary, my assessment and conclusions in respect to the impact on birds, both direct and indirect, as a result of the proposed coastal erosion protection at Glen Isla Place remain the same as outlined in my evidence. Overall, both the direct and indirect impacts on avifauna have been addressed through the avoidance of permanent habitat loss and the inclusion of consent conditions to ensure implementation of appropriate mitigation measures should construction occur during the breeding season, noting that it is the intent to undertake works outside the breeding season and through the preparation and implementation of an avifauna management plan. I'd just like to note that while the council and GIPS engineers have differing opinions on the location of the southern end of the structure, I consider the effects of the wall alignment anywhere between 5 metres and 1.5 metres from the property boundary to be the same on the avifauna. Thank you.
Thank you, Dr. Bull. See if we have questions for you. No? Amy?
Good morning. Just wondering if you're aware of the other dotterel breeding sites along Waihi Beach.
Yes, there's another one that's further north, much further north, up by the township. Correct.
And I assume that with construction happening during winter and then the breeding season starting in around about, is it August or September,
Correct.
that if construction was happening, that would deter dotterel from using it as a breeding site because of the disturbance happening there?
Correct. So if construction was undertaken during the breeding season, it would deter the birds from using that area, hence the reason trying to undertake it during the non-breeding season.
Okay, thank you.
Now, Dr. Bull, at paragraph 9.3 of your primary evidence, you addressed the regional council conditions and you suggested some slight amendments to the wording that they have imposed.
Correct.
Apart from those wording amendments, in your view, then do the regional council conditions adequately cover the matters that are relevant to your expertise?
Yes, they do.
All right, thank you, Dr. Gall. Thank you very much for your evidence. No further questions from me.
Thank you.
Thank you, sir. That brings us to Mr. Keesing, Dr. Keesing is the next witness.
We have in our inbox some summary statements, so we'll just bring up this Dr. Keesing's one. Yes, good morning and welcome. Same with other witnesses. Thanks for your evidence. We've read that, but we're very happy for you to take us through your summary statement.
Okay, try and make it short and sweet. So, starting at 1, the site into which the wall is to be installed is predominantly exotic coastal vegetation, despite the Bay of Plenty Regional Coastal Environment Plan labelling it as Indigenous Biological Diversity Area B. Most of the site does not meet the Coastal Policy Statement 11A or B, but the southern narrow portion, which is some 70 metres in length, is sufficiently Indigenous in vegetation cover that it does meet Policy 11B too. The most valuable Indigenous representative area of the site, the Spinifex Fortune, has purposefully been avoided. There are 2 possible wall alignments, and the level of adverse effect with either alignment option is very low. The effect of the southern Pohuhu section is allowable under the Coastal Policy Statement 11B, where that effect is remedied or mitigated. Whichever wall alignment is preferred, the remedial revegetation of the buried wall by Indigenous coastal appropriate vegetation causes a better than current condition and ecological value to occur. There is a low risk of the presence of native skink or any invertebrate listed by the Wildlife Act. Clearance processes will need to be in place to manage lizard salvage, and that process, in the absence of survey to prove absence, will require a wildlife permit. The remedial actions should have the management proposed in condition 10.5D, which states a 2-year maintenance period, or where there is 60, or in the District Council case, 80% cover of Indigenous species. No submitter, including the DOC, raised issues or provided new data that have changed my opinion on this. The reporting officer agrees that the ecological matters can be managed through the resource consent conditions, and a small range of management plans are required, to which I agree. The 2 points of disagreement are firstly the length of time that the management of the site by the applicant should be required, and secondly, the area of revegetation south of the wall installation. In my opinion, the applicant's responsibility is over once the revegetation is established, as the site will have had the effects of the application neutralised. In fact, the ecological gains. And the area will then be as prone to change as it is currently. Also, if the dock reserve under storm conditions, it's the reserve to the south, erodes near the southern end of the wall such that the vegetation is lost, it is largely exotic and will regrow by itself, and I fail to see why the applicant should be responsible for the revegetation of that area. Certainly it shouldn't be in a better native assemblage restoration.
Dr. Keesing, I see we have questions for you, Annie.
I see for the council, Mr. Shaw, the council's ecologist has recommended a sand and vegetation management plan. I don't think that you agree with that. Can you just explain your thoughts along those lines?
I do agree there should be a restoration management plan. All I disagree with him is that it shouldn't be ongoing forever. So there should be a plan that tells you how and what should be planted and where.
Sorry, I didn't see a restoration plan proposed in the conditions.
Remediation planting plan condition.
It's just not, it's called remediation planting.
That's right. Okay.
Not
I
restoration.
would have searched management plan, sorry. I got my terminology wrong. Okay, thanks for that.
Condition.
It's also fully documented in the regional council conditions. Yep. Chair. Dr. Keesing, no questions, clarification for you. I found your evidence clear on its face, so I think that.
Thank you, Mr. Chair. That then brings us to Mr. Coombs, who's the next witness for GIPS. And in addition to his summary statement, you do also have that additional simulation from him, and you'll have seen that I, to the extent that I was able to as a lawyer, I gave some description around that simulation, but I would suggest that Mr. Coombs perhaps volunteers to talk you through a little bit how that simulation has been prepared as part of his evidence in addition to the summary.
Yes, good morning, Mr. Coombs. Thank you very much for your evidence. We're happy to hear from you at this stage.
Good morning, Commissioners. Thank you. I do propose just to take you through the key matters in my summary, and then I've got some pictures to share with you as well, so I can explain those further.
Great. We always enjoy visual presentations, so happy to receive that.
The remnant natural dune at Glen Isla Place has eroded since historic erosion protection was removed and the 3 Mile Creek works were constructed. Erosion from Cyclone Gabrielle in 2023 exposed further historic erosion protection structures, which underlie the existing sand dunes at Glen Isla Place. The erosion and the exposure of the historic seawall works under the natural-looking Glen Isla dune would have ongoing adverse landscape and natural character effects on the beach. Waihi Beach is part of Outstanding Natural Feature ONF S24 in the Western Bay of Plenty District Plan, which is a generic up to 100 metre offset from mean high water springs. ONF S24 includes the natural beach and dune systems, as well as erosion protection structures further north on the beach, including the front edge of Glen Isla Dune. Submissions on the applications and technical reviews from council advisors have been considered and responded to, in addition to any concerns that have been raised on natural character and landscape effects. The erosion protection structure has been designed to be integrated into the remnant dune system as far as is possible, with the structure entirely buried after construction, with the potential for exposure of one end after high energy erosion events. An alternative proposed location for the southern part of the Type 1 wall, partway between the 5 metre property boundary offset and the boundary, has been considered, and while the effects are acceptable in landscape and natural character terms, the 5 metre offset location is preferred in landscape, natural character and visual effects. The Glen Isla Place erosion protection structure is consistent with, and in some respects, is a better outcome in natural character and landscape terms than other existing erosion protection works at the beach. The erosion protection structure at Glen Isla Place can be developed to ensure that it protects the natural character and landscape values of the beach and protects the reserve and adjacent properties, leading to positive overall natural character and landscape effects.
Did you want to lead us through your visual presentations?
Yes. So at your request, we went back and had a look at the visual simulation that we'd prepared and showed what a Gabrielle type erosion event would look like. This might take a while. It's a big file. No.
It took a long time to download, but we do appreciate it.
So it's going to work. So this is the view taken, I think it was approximately just over 12 months ago when we took that photograph.
Sorry, Mr. Coombs, can you just physically pull the microphone closer to you?
Sorry, yes. Yep. So that's the existing site condition. This is what the front edge of the dune would look like post-construction with the sand and planting fully established. And then after some conversations with Mr. Davis last week, this is the extent of the base of the wall that would be exposed by a Gabriel type event. So you can see there's sort of 2 to 3 rows of rocks all the way along, and then to the left of the end of the wall, you can see some more scour on the front face of that dune where the vegetation's just fallen down over the front edge, which tends to happen. And then the final photo, probably wasn't a lot of point in trying to do a visual simulation of what it would look like in a Gabriel event without the wall, because this is the photograph that was taken just in the same month as Cyclone Gabriel. So you can see there's a 2 to 3 meter vertical face and the vegetation's all dropped down over the face. And then just one thing to note, you can see there's an area of dry sand at the top of the beach. Further north, where the rock revetment walls are in place, that's all within the CMA, so it never gets a chance to dry out. And that's one difference with having the wall in this location, is because that sand at the back of the beach dries out, it's then mobile and it gets blown back up onto the face of the dune. So it's a key difference in terms of the sand being able to rebuild over the face of the wall. Happy to take any questions there.
Thank you for that. Had any questions, Mr. Coombs? Sorry, no? No. Amy? Just turning to your summary statement, your paragraph 6, and I know you cover this in your evidence, but it'd be helpful if you could just summarise for us briefly why you think, from a landscape and natural character and visual effects perspective, the 5 metre offset is preferable. Maybe you could just summarise that again for us in your own words.
I guess the key response to that is that you've just got more landscape and more landform to work with, because you've got 5 metres of protected reserve and behind the wall. And so if that's got successfully established spinifex planting on it, then there's something that can grow forward. Whereas if, for example, that wall was built on the boundary and there was no planting in behind it, you've got nothing to work back from in terms of the planting. So, you know, having more surface area, more habitat, sort of more potential for coastal access into the future, it just gives you more landscape and more landform to work with.
And you'd see that as particularly important in terms of, I guess, nature rehabilitating itself post an erosion event that would expose the wall. Is that what I'm understanding?
Yes, yes, it is. It just gives you more planting and more sand to work with, more of a buffer.
Well, thank you very much. I don't have any further questions, clarification for you, but thank you very much for your evidence, particularly the visual simulations, which I certainly found to be very helpful.
Thank you.
Thank you.
Thank you, Mr. Chair. That brings us to Mr. Whitlock as the next witness for GIPS.
Kia ora koutou. Yep, just bear with me a sec. Right. Good morning, Mr. Whitlock. Thank you very much for your evidence. Happy for you to lead us through your summary statement. Then we'll see if we have questions for you.
Thank you. So I've measured noise and vibration of representative revetment construction activities at the site. I used this data and conventional acoustic modelling to predict noise and vibration levels at all dwellings in the vicinity, including those owned by the applicant. I predict that all construction activities will comply with the relevant noise and vibration limits at all receivers, with the exception of a 2 decibel noise infringement at the closest applicant-owned property. Several submitters have expressed concern about vibration-induced damage to dwellings, but my measurements on site and calculations indicate this risk is very low. Council's planner and acoustic expert, Mr. Stiles, agree with my findings and agree with the conditions they have, and I agree with the conditions they have proposed to manage noise and vibration effects, notwithstanding a small typo I noticed in their draft conditions and pointed out in my evidence. As part of the Section 41A response, I calculated noise and vibration levels from an alternative revetment location, which is slightly closer to all dwellings. I predict this would increase noise and vibration levels for all dwellings, but only one additional applicant-owned dwelling would infringe the noise limit. Happy to answer any questions.
Thank you for that. Mr. Whitlock, I found your evidence really interesting in terms of the vibration trial that you undertook. That was, I haven't come across that very often before in the hearings where I've been a commissioner. How common is it in your experience to do actual trials of that nature?
Not that common, but it's very useful. Of course, there are many variables in vibration prediction. So being able to measure, accurate and capture accurate data from on site is invaluable.
Yeah. So how many, in your experience, how many other similar trials have you been personally involved with of that nature?
That involved a trial?
Yes.
For noise, I've been involved in a handful, maybe 2 or 3, but none for vibration.
Okay. Mr. Faithful, just remind me what condition number is the vibration condition in the volunteer district council consent?
53 through 61.
Oh yes, thank you, I found them. So Mr. Whitlock, have you got those conditions handy, or Mr. Faithful can put them in front of you? I just want to ask you about condition 60.
Sure.
And you refer there to the German industrial standard, which certainly in my experience is the one that everyone uses around the country. Other consents I've been involved with, though, they have included actual vibration limit numbers and conditions. Did you give that any consideration in this case to actually put some numbers in there?
I did. So these conditions were proposed by Mr. Stiles. I didn't consider changing this condition to include the numbers. I take the point that it's more instructive, I guess, for a condition to include the numbers themselves.
Yes.
Really, the only people that understand the standard and apply those numbers are experts like myself and Mr. Stiles. So I think it's sort of 6 of one, half a dozen of the other, but I wouldn't have a problem with including vibration limits in there. I like to try and, I like to see conditions that are nice, clean and concise. And the German standard has has vibration limits both for short-term and long-term. And so if you're going to include a fulsome account of the standard, you'll be using up sort of a page and a half just to get all of that information across. So I thought going concise was preferable.
So if a number was to be included, would it be 5 millimeters per second PPV? Would it be the one you'd go for? Or?
It would, yeah. So the nature of the construction works, I expect they would generate short-term vibration as per the standard. That 5 millimeters per second limit is for 1 to 10 hertz. So the short-term standards are different depending on the frequency of the vibration in terms of cycles per second. And 5 millimeters per second is for the 1 to 10 hertz band, which is the most stringent of all of the standard, all of the limits for the short-term vibration. Yeah.
Right. Well, thank you for that. I mean, part of our decision-making process, I'm asking a lot of questions about conditions for anyone watching on Zoom. The reason for that is it's a big part of our decision-making basis is whether or not conditions can adequately deal with potential effects. So that's why I ask a lot of questions about that.
Sure.
So I'd appreciate you sitting down with Mr. Faithful and, if possible, before the end of the hearing, but certainly in reply, if not, to come up with a revised condition that actually has a numerical value in it. And I understand, wouldn't it be necessary to specify the hertz frequency? Would it just be a simple millimeters per second?
I think applying 5 millimeters per second, it's conservative, but I think it's appropriate.
Yes.
Yeah.
Yep. All right. Thank you. That was what I wanted to ask you about, but thank you for your evidence.
Thank you.
So we've arrived at the afternoon session this morning. So
We should press ahead.
I think we should press ahead.
Indeed.
Yes.
So Mr. Davis is the next witness.
Commissioners.
Yes, good morning, Mr. Davis. Thank you very much for your comprehensive evidence. As before, we've read that. But, we're very happy for you to lead us through your summary statement. But of course, in your case, if there's anything in your primary evidence you wish to draw our attention to, you should do that, because certainly coastal processes is one of the key matters that we need to turn our minds to. So, over to you.
Thank you. I have tried to catch the key issues without reiterating it. So I think yeah, we'll go through this and obviously there's questions you can ask. I think I've said the key erosion issues is the first thing I just want to point out, and that was the walls got two key reasons, and that's from short-term storm cut from a large storm of a size that we haven't seen on the monitoring record, and then enduring protection as the shoreline retreats due to coastal climate change driven sea level rise. I make the note the groins in the intertidal area on either side of the creek mitigate to an extent the effect of 3 Mile Creek stormwater course outlet. Erosion tends to be greater around a watercourse outlet on a sandy beach. I'll just go through sea level rise and climate change. There is a little bit of confusion, well, not confusion here, but there's been more reports since we did our original evidence. So I'll just run through what there is. We did the engineering design and assessment report adopting the hazard lines that had been produced by the 2015 Donkin and Taylor report. That was the best information, and I felt it was going to be very sensible to use the adopted hazard as our retreat, as our future rate. So there was no debate over what was the adopted rate was, and that report seemed reasonable at the time. Since then, I note there's just a new 2024 report being put on the website. Last I looked, it hadn't been adopted by council, but no doubt will be. That is been based on 2017 guidance from MFE. I noticed they do also reference the interim advice from 2022 from MFE, and it's now been 2024 guidance from MFE. So I guess what we're saying there is there's been a lot of additional advice regarding provision for sea level rise. The coastal process assessment and engineering design have been reviewed against those updates, and I think the conservatism in the initial analysis has resulted in the analysis being consistent with these updates, mainly because the difference in predictions, especially over the near term, is relatively small, but obviously becomes more divergent over greater timeframes. And that's the sea level rise increases exponentially, but has been modeled to occur linearly. So there's some conservatism, especially over those first few decades. And I think I've got a figure in my evidence 615 that just highlights that. The assumptions for shoreline retreat and all the guidance and hazard work are conservative and precautionary in planning documents, as they should be. And so the likely retreat to be experienced is likely to be less than the precautionary allowance. Excuse me, this out. So the engineering report used these conservative assumptions consistent with the adopted hazard lines. And I have included in my evidence a table indicating more likely scenarios, wall exposure. So that's a table saying in my engineering evidence, I've given, assuming the hazard lines, this is where when the wall will be exposed to a certain extent. I've then gone back and then using the SSP 4.5, given an alternative amount of exposure of the wall, and that's in table 3 of my evidence. So that's what the two assessments of exposure are at that point. Just turning to the extent of potential storm cut, the beach has been regularly monitored since 1990, and the worst, most shoreward the erosion has been is during the Cyclone Gabriel hazard events. So that gives us an idea of historic storm cut. Just statistically, it's about a 70% chance, given we've only got a 35-year record, that we haven't seen the 1% AEP storm cut. So that it's most likely there'll be worse storm cut than what we've seen at Gabriel at some stage. There's been historic predictions of storm cut. Economist Jim Darm's done a lot of work on the Coromandel Coast for a long time, and his estimates were in the order of 35 to 40 metres. TNT 2015, we're talking about 20 metres. The more recent report was 18 metres. The way the 2024 report does it is they provide a 5% chance over 10 years of 18 metres. Again, that sort of over a 50-year period means there's 22% chance of such an event occurring, which is quite high if that's going to be failure of a building that's storm cut. And I guess that goes to why we think walls necessary for storm cut. There could well be much higher storm cut than we've seen to date in monitoring record. I'll just say the most recent report from TNT does use some good statistical work, but there is some need for care when we haven't had many large storm events to take too much accuracy in the statistical analysis. So I guess that's, in my opinion, we need to be careful of the future storm cut-ins while we're providing the wall. And I make the note that storm cut of the scale predicted would damage the gyps properties. And I've done a little diagram in the report that indicates that. Options assessment and project design. A rigorous options assessment for options to mitigate the erosion risks was undertaken, including a do-nothing, managed retreat, and soft engineering measures. The assessment was that the best option is provision of an enhanced dune system in front of a rock revetment backstop wall. The wall placed sufficiently landward to allow those dunes to function in most beach states at current beach levels. Analysis has considered progressively retreating beach over time. So we've looked at how the wall will perform over time as the beach retreats, if it is to meet the beach retreat predicted by the hazard report. And the wall's been designed to withstand instant wave conditions over the progressive retreat. Wave conditions will increase, wave height will increase as water depth increases in front of the wall. The wall is intended to be covered with sand and planted with native dune binding species. and we'll be putting wind fencing in place to protect those planting and while it's establishing. Based on the historic monitoring record, the upper crest of the wall would have only been exposed once in the last 35 years, and that was the Gabriel Hale event series. And this distinguishes the proposal and the wall part of it from the existing rock walls further to the north. We'll come back to how very different they are to the walls in the north a little bit later. Construction methodology, we've talked about access will be along the northern side, and the high value dune vegetation will be fenced off prior to commencement. We're trying to work within the footprint of the wall and in a progressive or sequential way so that we do minimise that area. And we've done a little bit of work in that our construction management plan, so we've convinced ourselves that that can be undertaken. I don't think it'll be particularly easy, but I think it can be undertaken. May need some temporary works, as I've indicated. We are talking to beach contractors who are have a lot of experience doing work of that sort. And I make a note that all machinery has been used previously dredging 3 Mile Creek regularly, so we're not introducing anything new to that environment. Potential wall effects. Obviously, while the wall is buried, as long as we can have the dune functioning, the wall won't have any effects on coastal processes. At current beach levels, we will see under occasional storm events like Gabriel, you'd have the top layer of wall exposed. I think the image was useful that we saw. The wall would have vegetation over the top, and the stolons and spinifex does tend to drape over the top of it and help re-establish the dune in front of it. Sand will naturally return and rebuild over this area of beach without intervention. And that's just normal dune processes will occur in an area if you put the wall in an area where dunes build. With long-term beach retreat or in a very large storm, more of the wall will be exposed and some localised edge effects would be expected. So in the likes of the Gabriel event, I wouldn't have expected any edge effects because there would have been right at the top of the uprush of the water. And I think there's severe storm cut right the way down the reserve. I don't think there would be any different if there'd been a wall there, or not noticeably different. But I think as we have a very big storm or we get more retreat, and so we have more of the wall exposed, we would get localised effects at the southern end of, and I've given an estimate of what sort of area there we might see as a bite, and that's looking at a couple of seawalls from Gabriel. Particularly, there was the shark bite at Whitianga was a very noticeable one up there. We were involved with another one on the south of Whitianga, which was a beach without seawalls, but there was a large tree in front of the property we were doing, and it had a similar sort of extent of end effect, if you like. The sort of end effect we have, I mean, it goes to, you're liable to have some similar variations in the natural shoreline too, that you have these areas that get eaten away most. And I will note that this end effect's just a temporary increase in erosion at that area by 5 metres or whatever it would be. Localised scour at the northern end will cause some retreat in front of the northern intersection. Sorry. See the southern end, impact on the southern end would cause effects in front of the northern end with swash being angled down that wall to an extent. With ongoing beach retreat, eventually swash would run right to the end of the northern end, we would think. At that stage, if the groins were in place, they'd contain dissipated squash quite well. If the groins were not in place, I've shown that we could easily provide an end detail that would deal with it at that stage if required. But the chances, if the groins were not in place, then wave approach would be quite different in any case. And you'd have it, have the river mouth acting in a wider manner, and you'd have tend to have more shore parallel waves at that point anyway. Beach lowering in front of the wall as a result of wave interaction with the wall is unlikely to occur beyond scouring during storm events, occurring more quickly than if the wall was not there. So scour depth is unlikely to be different. And what I'm saying there is I don't think the beach would be lower just because we've got a wall. A beach lowers under a storm event, and it arguably happens a little more quickly if there's a more reflective surface, but the level it gets to is very similar. And I've gone through end effects and front of wall effects in some detail in the engineering report. So I'm quite happy to talk about that a little more if it was questions. Typical issues with the seawall, we talk about trapping sand or acting like a groin, and I don't think this wall would do that, especially if there's long groins at the stormwater outlet. Just a few comments regarding the council assessment. I note in the council's engineer has discounted the value of public access behind the wall because it's not used at present. And of course, at current beach levels, there's no need. It's a nice wide open beach, but as the beach retreats, that wall may become more valuable for public access. So I just want to emphasise that its current use may change over time with beach retreat. And obviously, if the wall's not there, then that land will be lost. Mr. Davidson asserts the northern part of the wall, or a portion of it, isn't necessary, and we can rely on the ongoing presence of groins. And I think Mr. Slyfield touched on this seems to be a poor approach to allow on for something that's only got a fixed consent duration 2032. I also note that the groins are the most landward. I haven't got some evidence. Is the most landward. I will refer to in my evidence section 1115, but they're the most seaward, structures. So they're not likely the most affected by sea level rise first. So by the time we're worried about the rear of that wall, council will have either had to upgrade those groins or may have abandoned them, because with retreating beach, the very ends of those groins are going to become the first part of the strip of the beach to become a maintenance problem. If there's a major storm cut event of the sort that's predicted under the maximums I talked about, then irrespective of the groins, you're going to need some seawall in front of most of the GIPS properties. We've got agreement with the proposed structure of sound, and I think we've talked about already how Mr. Davidson suggests the wall could be located close to the private boundaries. And I think there's a trade-off in benefits by delaying exposure of the structure. First of all, I agree that there will be longer till the wall gets exposed, and therefore I guess there'll be a period where there are less effects, and there will be storm events. Potentially there are storm events where if we've moved it back, it won't be exposed where it would have been if it had been 3 meters further seaward, if that makes sense. If we move it back, it may get exposed less often. But I guess there's a trade-off between the marginal benefits of having it further back or the value of the land above the wall. I'd prefer the distance of 5 meters off, because I think from a coastal management perspective, you're still achieving ability to have public access, and you have that residual spin effects above the wall more quickly to rebuild the dune. But either from an engineering perspective, either of those options will work. We've had my work peer reviewed by Mr. Clark. His recommendations, he made some recommendations for raising the level of the geotextile under the wall, which I've altered in the design. It's a detailed design matter, but agreed on that anyway. So, conclusion, the project is unlike the rock walls on the North Waihi beach, and I stress that, and I think probably that's something that the submitters perhaps didn't understand. I think even as a project team, as we started this project, it's very hard to walk past those big rock walls and not get in your mind that this is what's being proposed. But if the rock walls are far enough back, obviously you're never going to see them. If the rock walls are too far out, they're going to be a disaster. And what we've tried to do, and I think it's a good trade-off, is to have walls set back as far as we can, that we'll have dunes happening at current levels, beach levels, dunes happening and operating most of the time. And then in those big events, if we get a big storm cut event that's bigger than we've seen at Gabriel, or as the beach sea level rise occurs, we get a large Gabriel type storm, the wall will be there to protect the properties. So we've tried to use all the sensible software engineering options, but ensure protection of those properties.
Thank you for that. See if we have questions. Amy, we'll start with you.
Thank you, Mr. Davis. I noticed in the review of your work by Mr. Clark that he commented on overtopping, and I don't believe I saw that in your report. I was just curious, was the site overtopped during Gabrielle? And then I guess if overtopping is an issue at some point in time, how will that impact on the plants regenerating the dune?
I understand. Sorry, Nicholas. I understand there was some overtopping from at Gabriel off the bank. There's not a huge amount from what I saw, because the vegetation was still pretty intact at the top of the mount. But I understand there was a small amount of overtopping. I think the way riprap wall, especially at a dune front riprap wall, is designed, it's as long as it's got good protection from the returning water, that can't remove the fines from behind it, they're very resilient to overtopping. And what Mr. Clark suggested is we take that fines barrier up a little higher, and so that's what we've done. That will raise that level at the back. I'm happy. I mean, we looked at that wall on the assumption that it basically goes right through to failure, that as the beach retreats, the wall will get heavier and heavier wave events. And so it will need to be detailed well for overtopping. I think overtopping is something, you have a massive storm, you'd probably go along, and if you need, and this is talking when the beach, either it's a very big storm we haven't seen, or we've had significant retreat, and that would be only at that stage we get overtopping. But if you have a big storm in that case, for a Gabriel type storm, you'd have some sand get removed, spin effects would still be together, and as long as that's still within the area that where an incipient dune will form, the sand will come back and it'll take some time. As the beach retreats further, that it will get washed, that sand will get washed off the top, and it will get to a stage where potentially there'll be periods where spin effects can't establish there. And that's where it would be really good to have a little bit of hinter-dune between that and the mown lawns that does have native vegetation, because that will just provide that vegetation base for it to start growing out again when you get a period of higher sand level. As the beach keeps retreating, obviously that gets to a stage that you can't establish a dune there, because it's just not in a place a dune can establish.
Thank you. My other question related to a comment that Mr. Coombs made in terms of dry beach width, I guess.
Yeah.
So with the proposal, we're looking at either a 1.5 metre offset or a 5 metre offset. I would assume that if the structure was closer to the boundary, then there would be a longer period of time that the dune could naturally recover in front of the wall, because there would be more high tide beach available. Does that make sense?
Yeah. I think, yeah, you're exactly right. The further back we set the wall, from a purely hypothetical basis, further back we set it, the more time the beach will function naturally in front of it. Quite right. And I guess with retreat, the longer it will be within the zone that a fore dune wants to form naturally, and so will become naturally covered. The difference, I guess, is where we get into how much difference it's making with that 3.5 meters. It's a notional hypothetical thing, and it does become a balancing act between how much you value that extra 3.5 meters, or how much you value having that public space at the top. When the wall, especially in the first decades, will only be influenced by big storm events. So this is a very short time. We'll have a big Gabriel event, and then sand will come back in front of it. And so there is that period that none of us are exactly sure the difference, how long the difference with retreating beach will make 3.5 meters difference. I suspect it's not very much. And that's why from my point of view, I can see that it's worth having that backshore connection there. I've been in lots of situations where there's a long esplanade reserve and there's a gap in the backshore. And it doesn't matter at Waihi Beach because there's plenty of high tide beach at present, but that is going to change over time. So that's why I think I'd err on the side there of having a better provision there, because I think it'll make almost no difference in the first couple of decades, and then there'll be some period where it does make a bit of difference, but how much that is, I'm not sure.
Thank you. I had similar questions, just thinking about the balance between trying to accommodate, whether it's landscape or whether it's ecology, or from a functional point of view, public access and public use. So I appreciated your evidence in terms of your expertise and what you're trying to do. And I think that's probably the challenge for us, is how do we balance all that up, taking into account all of the evidence put before us. My question was probably more in relation to the top 2 section, and whether you had thought about or considered. I know the proposition is you want both, what the applicant's seeking is both type 1 and type 2 to be constructed now. But whether you thought about or considered an adaptive management kind of approach or staging. I do take the point about the groins and the time frame and the consent period that's set for that. Yeah, so I suppose my question is whether you considered an adaptive management approach to your thinking.
So I guess in terms of the way the solution has evolved, it's based around, I guess, to an extent, an adaptive approach of using dunes while we can, and then having a seawall once that doesn't become viable. In terms of the return on the wall and whether we could do that in an adaptive way, and develop a trigger of some sort with, when you get to the stage, then you could go in and build that. There's some value in that, because there's certainly the time available, I would think, to do that. A large storm cut event, you're still at risk from a large storm cut event, but it would have to be a larger event, and it's very hard to predict what the largest event is. But I think probably the most telling thing is I think construction is going to be reasonably difficult when we have high value vegetation seaward already and a limited area landward. So the access to that part when we build it will be coming around in front of the section 1, type 1 if you like, and then working along that wall from the far end and working out. So it will be difficult to come back in and do that and get rock in there. So that's a practical issue that I think would be hard to solve. My preference would be to build it all anyway, to be honest, because knowing quite where that end is a difficult question as well. You certainly want to build the front. You're going to want to build around the corner. because there will be some end effects in a wall at an angle to the oncoming waves tends to have a more of an end effect than the one at the other end. So you're going to want to provide for that. And I think you get to the stage pretty quickly that it's, well, I'm going to go to here and I'm going to leave this little piece out and just give them what's in the environment. And you're going to establish this, hoping to establish a lovely dune in front of it. And then, and admittedly, by the time we come to do that, but hopefully that, you know, maybe that dune's not as lovely. But the idea of going back just seems, besides being very expensive, doesn't sound like the right answer to me.
Ms. Davis, we've got a couple of matters I'd like to take you through, and I can use your summary statement as prompts for those questions. So just your paragraph 23 in your summary statement, just as a prompt. The end effect at the southern end of the type 1 wall, and I was trying to, but I couldn't establish from your table 3 in your primary evidence, which I found quite helpful. When roughly do you think the shoreline would have retreated such that the end effects that you describe in your paragraph 23 might start to be seen? Are you able to put a rough figure on that for us?
I'll just have a look at that. So the table 3 in my evidence you're referring to here.
Yeah, where you give various time frames.
Yeah. I'll just try and fit in with those. Because I guess those are my best estimate of what's going on, but I guess they're representative too, as to the state of the wall. So I think by the time you're getting to we talk about the top metre exposed for long periods, and during storms you've got 1.5 to 2 metres of wall exposed. I think you're then getting some localised effects at the end. In a big storm, so an uprush, you'd get some localised effects at the end. So somewhere in that and that's, I'm talking that that's the 10 to 20 years. Well, realistically, I think that's in the 25 to 35 years. And I think it'd be in that sort of time I'd expect you'd, with the predicted retreat that we're expecting, and assuming beach reacts the way we're expecting it, that it would be in that sort of time frame, maybe 20 years to 30 years, you'd start getting end effects from uprush locally at the southern end. I think this is a case with end effects. I mean, in this case, you've got a large area of backshore at the top that's planted the same, and then you've got a large area of natural foreshore in front. So the end effects really are just moving the line between where that difference between those two environments is, which is just similar to a lot of walls where you've got another property with a backshore with a particular value that you may lose. And so I guess that's, I feel more comfortable about there being, accepting those end effects.
And the next prompt for my question is your paragraph 25, and it's the northern extent of the type 2 wall. I recall from your evidence you had a solution there if the groin was no longer functional, that you put a little hook on the end of that type 2 wall. So my question is, should that little hook be built now as a matter of precaution, or because you said it would be hard to come back and retrofit stuff to the type 2 in the future? So should that hook be part of the current design?
The hook could be built now if it had to be. I think I would prefer it not to be, on the basis that we're trying to protect that vegetation in front of the wall, and so that little hook's going to increase the effective width at that point. At the time that hook's needed, we're talking about the groins being removed, and there being major changes there. And I think at that stage to do some sort of detail there would be the sensible time to do that. But if it was a case of decision makers felt that that's needed there to rely on that structure, then I think we could build it now and that would be there. So my preference would be, I don't think it's going to be needed for a long time, and the time that would be most sensible to build it would be at the time the groins are being removed.
Right. And I guess in that case, if the groins weren't removed, the construction practicalities would be much less because you'd be able to access it from that end, wouldn't you? Yeah. Okay.
And the converse, of course, is if the groins are there, that you don't need that.
Don't need it. Yeah. Yep. Again, I'm going to ask you to look in your crystal ball. Your paragraph 32 is the issue of the 1.5 versus the 5 metre setback.
Mm-hmm.
What period of time differential would there be between the wall becoming exposed at 1.5 versus 5? Are you able to put any kind of guesstimate on that?
I think the first question to that, and it's a little bit of an avoidance, is that remembering that the wall will only be exposed and it'll be event exposed rather
events.
being, and so obviously storminess and increased storminess is an issue as well. So and uprush tends to erode the dunes quite a lot in the event because there's just no resistance. So the difference between an event that's going 20 metres up the beach and 23.5 metres up the beach would be limited, I think. So I don't necessarily think there'd be a huge difference, but clearly something 3.5 metres back is further away from, wouldn't have been exposed with Gabrielle. So there are times it wouldn't have been exposed. If I had to put a time on it,
yeah.
Can I just come back to you and answer
Absolutely.
that? Because I'd like to look at the retreat and provide you some basis for that rather than my gut feel.
Yeah, certainly. And next question is, should the wall become exposed in an episodic storm event? And we've seen how quickly the beach has recovered post Gabrielle. What would be your expectation for the wall, and referring to Mr. Coombs's diagram of the wall being exposed in a storm event, how long would you expect it to be before a more natural dune type vista had re-established itself? Would it be a similar period to what's happened with Gabrielle, or would it be a different period?
Oh no, I think Gabrielle's a good model for what you'd see in terms of establishment. So definitely from that storm cut event, you'll have to see a very similar thing to Gabrielle. With the Gabrielle event was a series of events. If you look at with hail and what have you, so it was a period of lower sand. And that period of lower sand, if that continues for a while, then you'll have to see see slower recovery of the wall. But I would have still, but we are envisaging the wall being exposed by the upper part on a storm-cut beach, which is naturally a place where sand wants to gather, because after the storm, obviously, it's not influenced any further. So it's a piece of sand below a dune between the shore, and so it's an area for an incipient dune to form. It's a natural place for it to form. So I'd expect reasonably quickly, similar to Gabrielle, you'd get incipient dune in front of that. I guess if you've got low sand levels, there's a bit less sand to come in front of that. So perhaps the recovery isn't quite so high, and you'd end up building halfway up the rock or something until you've got a bit more sand in the system if you're at a period of low dunes. So, I mean, my feeling is if you had that wall storm exposed, if sand levels were still reasonably high, it would be, sand's back there in 6 months, but it's probably a year before you're starting to get some vegetation growing through that. If sand's a little lower, maybe it's 2 years and it's maybe 3 before you can't see the rocks anymore entirely, something like that. The experience on even in our Auckland beaches, which are lens beaches, but a lot of them have rocks at the back, and that get exposed after storms. And when the sand returns within, I'd say within 2 years, easily you can't see the rocks anymore. Right. They tend to be covered by kikuyu, so it's a different example.
Yeah. So just to clarify, so I know it's hard to say with any precision, but you think realistically maybe a 2 to 3 year period for the rock wall to be covered by a vegetative?
I would say it's a 1 to 3 year period if you're looking for a number, and that's because if the sand comes back, it can come back very quickly and then be a big supply and cover very quickly.
Yeah. Okay. Now, not a question for you. Well, it is a question for you, but it's not related to this proposal. It's just a matter of curiosity for me. Back in the dark mists of time when I was designing coastal protection works in the Ministry of Works Development, if you remember that organisation, we used to use the US Army Corps of Engineers Shore Protection Manual. Is that still viable?
It is. It is. It's been it's now called the Coastal Erosion Manual, but basically it is. So there's 2 books now. There's that and a European Syria document, but it's still there. It's still one of the documents we've used most. Yes.
Yeah, well, that's interesting.
Yeah.
All right. Well, thank you very much. I think that's the end of our questions. We thank for your assistance, and we look forward to that little bit of further consideration you're going to give for us. Yeah.
Thank you, Mr. Chair. That does take us to Mr. Clark, if you would like to keep pushing ahead.
Yeah, I think, should we do this? Should we hear from Mr. Clark and then we'll take an early lunch because we have Mr. Faithful afterwards. So we're jumping from technical witnesses to an evaluative witness. So I think that might be a good pause point.
That seems appropriate. Thank you,
All right.
sir.
Thank you. Yes, good morning, Mr. Clark, and thanks for coming in early. I saw you coming in there with a bit of haste previously. Well, we're diligent readers of pre-circulated material. I just wish everyone would understand that it's not always the case. All right, over to you, though.
Sorry. They did circulate by email the summary points. Yep. I guess I was engaged to conduct a technical review of Craig's work. Typically, I often end up on the other side of this working for councils, but given everything that was going on in the hearing, Jips thought it prudent to get a second set of eyes on his work. In general, the work undertaken by Mr. Davis was found to be comprehensive and to a standard that is appropriate for an application of this type. All available data sets, previous reporting and relevant literature were considered as part of his review. My review is limited to the coastal process and coastal engineering aspects of his work. So on that, the coastal process assessment was found to be thorough and use all available literature. It's worth noting that Waihi Beach is one of the most studied beaches in New Zealand, and a lot of the conclusions drawn by Craig are backed up by work going back to the 1990s with the likes of Jeremy Gibb. Jim Darm and Economos reviewed it in early 2000s, and since then there have been a number of iterations of coastal hazard reports, the latest of which over the last 10 years have been done by Tonkin and Taylor. I think there's a couple of key points to note. There is a lot of uncertainty in terms of the erosion. I did hear discussing it with Craig. It's worth noting that a lot of the Bay of Plenty beaches and Waihi Beach in particular are different to some of the other beaches in New Zealand, whereas they don't just slowly erode at a known pace, which might increase or decrease year to year. There are decadal cycles, which have been shown to be linked to the El Nino Southern Oscillation. So you can get 10 years, in the La Nina phase, where the beaches are hit by more storms and erode frequently, but they have been repeatedly shown to recover when they move back into the other thing. So I guess the key point with that is if you've got a wall that's being exposed, if you're on a beach that's continuously eroding, then that's the end of it. The wall will be exposed, things will only get worse. But the actual ability of that beach to recover is higher than you'd see at other sites. But the actual timeframes of that, obviously, there's a lot of uncertainty. What is clear, though, through all this is that the properties at the southern end, at the more forward side of the proposed wall, are clearly at risk of erosion in the present day and short term. That's an ever-present risk, which is largely dependent on large storms and the storm cut associated with it. In terms of the wall that cuts back towards 3 Mile Creek, if we look at the wider coastline as a whole, then because of that setback, it's not a risk from that effect specifically. So if 3 Mile Creek wasn't there, that wall being so far back would not affect it. However, due to the presence of 3 Mile Creek and the interactions there, there is a risk of that being affected, and it is implicitly linked to the presence of the groin that's there at the moment. Without that groin and historical shoreline show it, and that is the reason those sections are set back, because when they did the original cadastral boundaries, the shoreline would have looked very different. There would be a risk to those sites. Just a small point for you to consider. I did note in my review that Tonkin and Taylor released an updated coastal hazard assessment, which was released publicly subsequent to Craig doing his work. I did review that, and it doesn't fundamentally change the analysis in Craig's report. There are just some minor differences on potential maximum setbacks. In terms of extreme water levels and design wave heights and the other aspects of the coastal engineering design, they're all found to be well-founded and reasonable for what was being designed. In terms of the structural design, from a coastal engineering point of view, I did raise some issues about the design and its potential performance. One of the main ones was the crest permeability. So rock revetments are semi-permeable structures, and they do rely on a geotextile behind the structure to prevent sand being washed out. It's my understanding, after talking to Gypsum Craigs, and I have seen an updated design drawing, that they've remedied this with the latest information you have. In terms of effects, the wall will get exposed. As I said, there's uncertainty when it will happen, but it's with sea level rise, it is a certainty that it will become to being exposed. The main effects are there will be a minor end effect at the southern end. Typically with rock walls, these tend to reach an equilibrium profile, and I agreed with Craig's assessment of a 2 to 5 metre setback, up to 50 metres in width on the reserve to the south of the structure. But this will only happen after most of the walls are exposed. So if you expose the top rocks, you're not going to get that effect. But over time, if it's fully exposed, you will see that effect. In terms of remedying that, there are other cases where they've put in conditions to remedy it, but because it reaches an equilibrium profile, it's almost futile. Because as soon as you place more sand there, it will just very quickly revert over the next few high tides to that equilibrium profile. Any sediment lost from the dunes isn't lost from the system, so it is recirculated in the wider system. Because of the angled setback of the northern side of the wall, you will get waves pushing and being funneled down that wall, so you will get a similar setback only once the wall's exposed, which will be another small concave area at the point the dune intersects the wall. But again, this does not inhibit recovery, and it will reach an equilibrium point. So it's not an ongoing sort of issue that keeps going. I noted that some concerns were raised about submitters about a potential for an increased flood risk due to the wall funneling water as they understood it down the creek. They were found to be unfounded and not too distinct from what would happen with a natural dune scarp after a storm event. I did consider the potential to set the wall back further because it kept getting raised as an issue. From an engineering point of view, there is very little difference in either position, but there are some benefits and disadvantages to either position. The benefits for having it, and it's not my area of expertise, but you can maintain a width of dune, which you otherwise may not have if you go up to the property boundaries. So there's probably ecological benefits to that. More for me, though, from a sort of construction and engineering point of view, thinking further ahead, if you've got that width of land, if you want to adapt that structure in the future, you've got the room to do something. Now, you could do it on other properties, but we've run into this before where properties change hands and people don't want to do things. So it would all be in the council's hands if the structure's vested to them to do something. Whereas if it's on private land, it can be more difficult. In terms of, as I say, performance of the wall in either position, they're very similar. You have got a slightly big buffer, and whether or not it would take the wall longer to be exposed, because you could have a major storm which would expose the wall in either position, you have got that larger buffer and you would end up with sand further up the wall after it's receded. So there are benefits from that from a coastal process point of view and beach recovery. But technically from a coastal engineering point of view and wall performance, there's not a lot of difference. As I mentioned, following submission of my report, I did discuss this with Craig Davis and GIPS, and to the best of my knowledge and from what I've seen, they've remedied everything that I brought up as part of the review, and that should be with you as your latest submission.
Thank you for that. Jeff, questions?
Thank you, and thank you for your evidence. And I'll just kind of refresh my memory to it. And thinking about the options assessment, so I think in your evidence you indicated you went through the options assessment prepared by Mr. Davis, thinking about the do nothing through to the soft options and the hard structures. And what's before us, I suppose, is a hard structure, but with some soft elements to it. I'm just kind of interested in your assessment from your perspective in considering the options assessment. Were there any other options that could have been considered or could have possibly been considered in terms of that assessment?
So I guess with all option assessments, it's just balancing pros and cons. There's no perfect solution. I fully agree that the purely soft dune replenishment option is not an option. Whenever you try and do that in a localized area on a wider beach, it doesn't end well. Beaches are very efficient at moving sand around to balance it out, which was borne out when they tried to do it previously. So in terms of an actual option as a soft defence, I don't think that's practical if you want to defend the boundaries. A lot of the other options were sort of more invasive sort of concrete structures and things like that, which I wouldn't support on an open sand beach. I think there's a lot more negative effects. In terms of exploring all the options, people have tried things before, which might have come up here, sort of timber piled walls which are put in on the property boundary. The issue is they have a lot of negative effects when they are exposed. If you take locations like Kapiti Beach, that was their approach there for a lot of their beach. They then got in a lot of trouble because the walls started getting exposed. Different residents, because if they're building on their own land, had almost been left to their own devices. So they're all different standards of protection, different quality, different building materials. And immediately as soon as they're exposed, you get a lot of wave reflection off those. So the beach did not recover. You get a lot of scare in front of it. And they had incrementally bigger problems with those getting undermined. So the way that played out was they started off by placing rock at the base of the structures to stop them getting undermined. And then they had more problems with the structures, so they end up building a rock revetment in front of the wall. Now, you could argue that's an adaptive approach, but what you end up with is no public access, no beach in front of the structures. And in my opinion, if you've got a backstop wall and the right conditions to manage it, so it's not a permanent solution. And I think GIPS recognise that if you go far enough out, 100 years, 50 years, depends how things evolve, they accept that something else might be needed. But in the short term, I think it has enough benefits if it's well managed that it's a preferable solution to just effectively pushing the beach back to the property boundaries.
And just a follow-up question in relation to Mr. Davis's table 3, I think in his evidence, and he kind of talked about it, the timeframes about exposure through various events. And do you support his assessment there in terms of how he's, I know it's kind of a pie in the sky kind of thing, you know, a bit of guesswork, but taking into account your expertise. Yeah, what are your thoughts on that table?
Yeah, so as I said at the beginning, I mean, it's almost an impossible task. You could sort of pin pins on a map and make guesses, but we're currently in terms of the Enso cycle in a neutral phase, and that's predicted to carry on for the rest of the year. Nobody knows if we're going to end up pushing into a La Nina phase, which will result in an increased erosion throughout the Bay of Plenty, or if we're going to flip into an El Nino phase, which would likely result in a lot of accretion in front of those properties anyway. So putting a timeline on this is very difficult. Now, what Craig's done is essentially averaged out the last 60, 70 years and said, well, this is typically how it goes back if you add it all together. So there are periods where it's increasing, periods where it's decreasing. And he's used that as the basis for his assessment. It's very difficult to put an actual time frame on it. If you told me how many storms we'll get over the next 10 years and how big they are, I could probably work it out, but obviously that's not practical. It will be exposed eventually, though. That is, as I say, almost a certainty. So we could go backwards and forwards on whether it's 5 years, 10 years, or how quickly it go. But the truth is that it could be in 2 years' time. We could have a really benign 10 years and it's not exposed at all for 10, 15 years. So I wouldn't like to put a time on it, but what Craig has done is averaged out over 70 years to give you an idea that based on that, those are the sort of reasonable timeframes. But realistically, it's going to be a lot better or a lot worse than that, but we don't know, I think.
Hi. In your evidence in the last paragraph of section 4.3, you talk about the southern end and how consideration could be given to moving that section of the wall landward to increase the sand dune buffer. Would that be achieved with the alternative proposal of having the seawall set back an extra 3.5 metres?
I'd say every metre helps. It's all relative to the size of the storm you get. And it would also aid the sort of recovery. Because the further back it is, the less of the wall you'll expose given the same event. So whatever event you're getting, it's going to be preferable in terms of the sand levels at the structure, however much is exposed. So 3.5 metres is enough to make a difference. That's quite a lot of sand when you look at it in a sort of volume sense. So yeah, further back, the better from a coastal process point of view. And I guess it's sort of your job to balance the other considerations on whether that's preferable.
And just to follow up on that same issue, I just want to make sure I heard you correctly. You said if the wall was set back 1.5 metres from the boundary as opposed to 5, I think I heard you say that would give a bigger sand buffer in front of the wall, which would assist with its recovery. Did I hear that correctly?
Yes, so the less it drops at the wall, the quicker it's going to recover. I should say that any hard structure on the beach can cause turbulence and inhibit the recovery, but rock revetments are semi-permeable by nature. They do absorb wave energy. And there are plenty of examples of rock revetments that get uncovered and recovered. With the amount of sand that's actively moving around on Waihi Beach, when you do get those recovery phases, it pretty much actively swamps everything as it comes back in. And you've probably seen the difference between the last cyclone and now on the sort of volumes that move. But yeah, the less you're exposed, the less interference it's going to have on the recovery process.
All right. Thank you very much. I think that brings us to a stage where we'll have an early lunch. Sorry, hopefully that's not going to upset the caterers too much. So we were scheduled to reconvene at 2 o'clock. I don't think we need to wait that long. Shall we say we'll adjourn for an hour and come back at 1:15? Is that, Mr. Faith, will give you enough time to figure out what you want to say to us?
Go now.
Yeah. Good to go now. I think we'll give you we'll have a break. We'd like a break. So is Nancy still here? No. Yes, would you please be able to ask Nancy to contact this afternoon's submitters, which is Robert Gillespie and Pippa Coombs, and advise them that we're proceeding much, much quicker than normal, or not normal, than we had estimated. We're going to reconvene at 1:15, and we're likely to be ready to hear submitters by 2 o'clock at the latest. So if they're able to be ready at 2 o'clock instead of 4:30, we'd appreciate that. I think tomorrow's submitters, we'll just carry on hearing from them tomorrow. They probably would have organised their lives around coming in tomorrow, not today. So we'll hear from Mr. Faithful and then the 2 submitters this afternoon, and then that'll be it for the day. Thank you. Well, good afternoon, everyone. It's just gone 1:15, so we'll reconvene the hearing. And Mr. Slyfield, anything you want to bring to our attention before we hear from Mr. Faithful?
Just one thing, and that is I've handed up that bundle of consents, and
Yes.
just in case you're tempted to look at them, I thought I'd just give you a little orientation about what that bundle comprises.
Mhm.
You'll see that there's a number of stapled documents in there. What I've done is I've stapled together each set of documents relating to each property in numerical order. So the first stapled set are all the documents relating to number 9, and then we go number 11, 12, 13, and so on. You'll see if you just look at the back of that first stapled example, the one thing that I have added into this set that isn't in the consents are copies of the actual covenants that are on the 3 titles that do have covenants. Now, I'm not going to take you through those in any greater detail. I'm happy to answer any questions that you have about them, or bring up anything in reply if need be. But that just gives you a bit of an understanding of what that material is.
Okay, thank you very much.
So that said, I'll hand over to Mr. Faithful, who has a summary statement as well that should be with you already.
Kia ora. Just 2 minor amendments to my primary statement that I just wanted to bring to light. Yeah, paragraph 726, there is a reference to Long Island in terms of the reserve. It's actually Island View Reserve. And para 9.2, after the term district plan, there is a number 20, just to delete that. I think that was a carryover footnote. Okay, kia ora. I can confirm that my evidence has been prepared in accordance with the Environment Court's expert witness code of conduct. It's within my area of expertise unless otherwise stated, and I have considered all the material facts relevant to my opinions. The GIPS is applying to the Western Bay for resource consent to construct a buried coastal protection structure on dune land in front of the waterfront properties at Glen Isla Place. The proposed structure is a buried rock revetment wall, approximately 200 metres long, running parallel to residential boundaries and set back 5 to 7.6 metres from the property lines. It's to be constructed using andesite rock from the local quarry, buried under at least 0.5 metres of sand and revegetated with indigenous dune plants. The proposal is a discretionary activity under the district plan, and Bay of Plenty Regional Council granted consents for activities under their jurisdiction in May 25. Technical evidence from both the District Council and GIPS supports the need for the structure, particularly the Type 1 section of structure in front of properties 12, 14 and 16 Glen Isla Place. Actual and potential adverse effects of the proposal have been assessed across multiple areas. There is general agreement that the effects can be appropriately managed through the implementation of consent conditions, including provision of a construction management plan, avifauna management plan, construction noise vibration management plan, remediation planting plan, and monitoring requirements. Positive effects of the protection of council reserve land, a strategic asset with ecological and future public access values, enhancement and protection of the dune environment, and resilience through dune restoration and planting, and long-term protection for the existing residential development. Well, the Section 42A report recommends declining the application on the basis of inconsistencies with the NZCPS, the Regional Policy Statement, and the Regional Coastal Environment Plan. It confirms the proposal is consistent with the District Plan objectives and policies, which gives effect to the NZCPS and the RPS. Regarding statutory matters, it is my opinion that, with respect to the statutory framework, the district plan is the primary planning instrument giving effect to the RPS and the NZCPS via Plan Change 74. The proposal aligns with these documents addressing coastal hazards, natural character and ecological values. Compliance with the NZCPS, the proposal is consistent with Objective 5 and policies 24 through 27, balancing hard and soft protection measures. Managed retreat is not mandatory and it is impractical at this time in this context. The structure protects public reserve land, a strategic asset, and enhances ecological resilience. I also note that it is broadly consistent with the other elements of the NZCPS. MPS alignment. The proposal incorporates.
Sorry, Mr. Faith, we'll just interrupt you a moment. For the gentleman at the rear of the room, hello. Could you please not have a discussion? It's a bit distracting. We're trying to listen to the witness. If you want to have a discussion, you're very welcome to take it outside, but you just refrain from doing that, please.
RPS alignment. The proposal incorporates soft engineering measures during restoration and is the best practical option for addressing coastal hazards. In my submission, it does not constitute an appropriate hazard mitigation. RPS consistency. The structure has a functional need to be in the coastal environment. It minimises adverse effects and supports ecological and public benefits. It aligns with policies CH9 and CH10 for coastal hazard management. Balanced approach. The proposal integrates hard and soft protection measures, is informed by technical evidence to address site-specific erosion risk while preserving natural character and biodiversity and appropriately providing for adverse effects. Precautionary approach. Effects are well understood, supported by detailed technical input and the design promotes resilience while avoiding significant adverse impacts. Managed retreat. Managed retreat, as suggested by council, isn't a realistic or practicable hazard response in this situation, noting its limited implementation in New Zealand to date, and when considering the limitations it has in respect to the GIPS properties, i.e. not applying to all structures or dwellings on the GIPS properties. For the reasons set out in my evidence, I consider the proposal aligns with the relevant statutory documents when properly considered in context. On alternative location, the council's engineer agrees a hard structure is justified, but recommends changing the alignment at the southern end of the structure to reduce the adverse effects on the coastal environment and processes, suggesting placement at the property boundary. I note that there was no comment from the council's other advisors on the implications of this change. While maintaining that 5 metres is the preferred location, the applicant's engineer proposes a compromise of reducing the distance to at least a 1.5 metre from the boundary. GIPS technical advisors support the retention of the 5 metre setback, but confirm that the effects are comparable if the structure is located closer to, but not on the boundary. I just wanted to make a point of clarification there. I think there's been a discussion around 5 metres or a 1.5 metres. I think what we're actually proposing is essentially an envelope where an effect would be comparable. So I think it's not a and or situation. If there was a balance of effects in 3 metres, 4 metres or something like that, I think that's the intention of sort of the assessment that we asked our advisors to undertake. Regarding the submissions, no specific technical planning evidence was lodged by any submitter on the application. And as the council did not provide a proposed set of conditions, the GIPS and its technical team developed a set of draft conditions submitted with the legal submissions. I acknowledge your comments earlier, Mr. Commissioner, around the duplication of conditions across the regional and the district consents. So while those were developed prior to that, we acknowledge that that current set probably doesn't capture those at all. And subject to any minor amendments arising from this process, I consider the conditions provide a robust and comprehensive framework for management and monitoring, sufficient to ensure the proposal is undertaken in accordance with the relevant statutory direction and that potential adverse effects will be no more than minor. Overall, it is my opinion that the proposal is a pragmatic and well-integrated hazard response that balances environmental, social and statutory considerations. It aligns with the statutory framework, ensuring effects are acceptable and consistent with regional and national policy direction. The proposed conditions will ensure potential effects are appropriately managed, and the 5 metre setback location is preferred. However, if the panel considers it necessary when balancing the potential temporal exposure effects and environmental effects, a location close to the property boundary would be acceptable.
Right, thank you very much for that. See if we have questions. Amy, would you like to go first?
Thank you. I'm just referring to your evidence, and I suppose my question relates to the long-term maintenance and exposure. And from my read, the evidence concludes that your evidence concludes that long-term exposure of the wall is unlikely and effects will remain no more than minor. What specific monitoring and adaptive management steps would you propose to ensure that this outcome of exposure does occur?
I think in terms of the actual design of the structure and the location has been developed with an adaptive management lens, and I think you explored that with one of the previous experts. I think by nature there is going to be a requirement of management sometime in the future, and whether that's an incorporation of a likes of a coast care program sort of coming in and providing for that, or something that aligns with the council's existing deposit of sand across the beaches, as they currently do with the dredging material from 3 Mile Creek, or the wider investigation and response that the district council decides to implement. I understand there was a sand push-up consent that was lodged with the regional council, but it was returned in May earlier this year, and that was a more broader approach in terms of management of that dune area and erosion over a broader scale. So I think it's a more of a combined, wider approach. To the extent that it's appropriate, I think the design, the location, and the subsequent replanting and those elements address a sort of an adaptive management style approach here.
Thank you. I'm just trying to read my notes. I think in terms of your evidence, you kind of emphasise the site-specific, locally supported solution in this context. And I suppose what's raised in the 42A report kind of concerns about approving the structure could undermine the strategic intent to transition communities away from kind of hard structures. Do you have a kind of a view on that, given the views of the council planner?
Yeah, I think there is the overarching erosion policy that, you know, the coastal hazard erosion policy that the district council has, you know, and there's agreement that there is consistency with the approach of that policy. I think again the design in itself is not a hard structure. It's that with the applicant and its design team have been very cognizant about sort of how can we put something within this location that is fit for purpose, has a functional need, addresses the broader effects, provides some level of benefit, you know, while recognizing that there is a site-specific need in lieu of any other intervention to address the risk that these properties face. So I think that by nature, the approach that has been taken is needed, while the broader sort of idea of the council to do nothing is not a realistic option for the people with these properties. And as we spoke to both Mr. Slyfield and others in terms of managed retreat and the practicalities of it at that location, it's not a provision that's tied to the main residential dwellings in any of those locations. So while a garage or other ancillary building may be able to be removed, the primary dwellings are facing a level of risk that, you know, while managed retreat in a greater form might be implemented in the future, it doesn't preclude the need or the ability for people to act now when there is an immediate response risk. Sorry.
Yep. Thank you.
Just got a couple of questions arising from your primary statement. The first one's at para 11.5.
Right.
Page 38.
Yes. Policy 6, is that
yeah,
correct?
Policy 6, NZCPS. Now, when I read Policy 6, I reminded myself of it. I failed I struggle to understand any relevance at all to the application before us. You say that it has, what are your words? You say limited relevance. Which aspects of policy 6 do you think have any application at all to our considerations?
I definitely think it's where it aligns is more sitting within the policy 6.1 elements, which speak directly to the coastal environment aspects. So I agree that the relevance of 6.2, there is none because those relate to the coastal marine area.
Yeah.
So that's the extent to which they are relevant. I agree they are limited in nature. And I do reference that I consider those provisions are very limited, have limited relevance to the proposal as they focus on those matters that are sort of broadly related to infrastructure, built development, urban growth, and those types of provisions there. There's nothing which specifically speaks to coastal hazard management. And there's no need for an assessment of alternatives or anything of that nature. But yes, it is, I think, it's very, very sort of broad in nature, if any.
Yeah. Okay. So my second question is at your paragraph 14.2.5.
Natural processes and beach function.
That's the one. Yeah. You say there, third line, if considered necessary, sand replenishment. Can you explain your thoughts behind that, the if considered necessary sand replenishment? What was going through your mind when you wrote that?
So I just acknowledge that there was a position where the council and some of their technical team proposed a sand and vegetation management plan. And so the sand replenishment was an aspect of that sand and vegetation management plan. As I said, the technical advisors on behalf of GIPS have all proposed that natural processes will actually help sort of the accretion around that wall if it is actually exposed. On the other hand, I also note that the council and its function as a sort of a manager, they have consents for the dredging of creeks and depositing of material, in areas along the beach. So I think if it was from a technical perspective or a need to get in there and cover up an exposure event, interact with an exposure event straight away, that might be a element of sand replenishment that may be required. But on the guidance of the technical advice presented on behalf of GIPS, I understand that is not required.
So in regards to that, would you see that once the if consent is granted and the proposal goes ahead and the coastal protection structure is vested in the council, then that would be a decision for the council to make at some future stage, and they may wish to use 3 Mile Creek dredgings, or they may wish to pursue their sand push-up consent, which I understand hasn't been applied for yet, but there's talk of it.
Yeah, and so I had confirmed through the regional council that to see whether or not there had been any consents from the district in terms of a response to that broader investigation that they were directed to do in 2020, I think it was, and then apply for consents off the back. And yeah, I was informed that there was a sand push-up consent lodged for the wider area of Waihi Beach. So I understand that is part of the long-term sort of proposal for the district council in terms of management of wider erosion issues. Yeah. I'm not sure under what grounds it was returned or accepted as or returned as incomplete. But yeah, I think if there is a source of sand, and I understand some of that sand is currently deposited in the northern section of the dune outside the Glen Isla properties, so it happens to be in the vicinity of where the dotterels do breed. So there is a demonstration of a disturbance in still a positive sort of breeding area. Yeah, I think there is a resource there that could be used if it was required.
Okay. So just in terms of that, Ms. Hill, when we hear from the district council tomorrow, I'd appreciate an understanding of where this sand push-up consent is at. We've been provided, I think, through DotWatch, a copy of Jim Darm's report, which was a draft report, but it was a very interesting read. So I think we'd be wanting to understand where the district council sits with that wider proposal. Yeah, Mr. Faithful, what I envisage you might be doing as part of the council reply, and I give leave for this to occur, Mr. Slyfield, and it doesn't have to be limited to legal submissions. You can attach relevant evidence. I'll give you leave to do that. But Mr. Faithful, what I'd anticipate receiving from you is a revised suite of recommended conditions that remove overlap with the regional council. And just to assist you in that regard, I've carefully gone through the regional council conditions and found them to be very comprehensive. But I have identified some matters that are specific to the district and aren't covered by the regional council. And so I'm just going to slowly list them out for you.
Yeah.
And it'll at least give you my preliminary thoughts on what, should we be minded to grant consent, what topics this district consent might usefully cover.
Before we get there, can I just make one comment on term? So I think that's being explored a bit through the questions to my colleagues here. I think the appropriateness of a term is one that sort of deserves a bit further consideration. If you're using an example of a constructed structure in a coastal environment that has a 50-year sort of design life on it, and if you're using that as a basis for a hypothetical scenario here, I think we have to consider that the structure is going to be buried. So, and the integrity of that structure, while it's buried, has an impact on the design life of the structure as in a really simple layperson sense. And I tested this a little with my colleagues during the lunch break. If it was covered for 20 years, you're potentially getting an additional period on top of that design life of that structure. So whether it's a direct translation of plus 20 years or not, I didn't quite go to that extent in terms of exploring it. So I think when you're sort of considering how that impacts the relevance of a term for a land use consent, I think that consideration in isolation gives value to the idea of having an in perpetuity consent term. And as Mr. Slyfield had proposed, that the terms of management, operation, use of the structure actually sit within the formal agreement with the district council in its function as the reserves and facilities team. So I think it's sort of, if you had a 30-year term, that the point at which, at that point, it would have already been vested with council. So council would then sit with the responsibilities of reconsenting, which could have some similar issues in terms of cost implications, significance implications that are being experienced through this process. And so I think that's something to also bear in mind when thinking about a term.
Yeah, obviously, should we be persuaded on the evidence that a grant of consent is appropriate duration, whether or not one should be imposed is something we'll need to turn our minds to.
Thank you.
Of course, the benefit of a duration of any fixed length is that it requires a fresh appraisal of the proposal or the structure in light of the circumstances that exist at that time.
Yeah.
And with sea level rise occurring, I mean, there's an argument that would be a beneficial thing.
Yes, and I think an alternative approach to that as well. And so in a lot of the applications that I've been involved in for sort of wastewater treatment plant discharges and similar aspects, there's an inclusion of conditions which require a technical review as such, which at certain periods over the life of the consent, you might actually look at the scenario that it's facing at that point in time and see if there is a need to change or adapt your approach through that. Is there some new science? Is there more technology? So that might be sort of a way that we could potentially balance out here too.
All right, thank you for that. So now just read out some topics that I thought district conditions could usefully cover.
So just to be clear, these are district provisions.
Yes.
Yeah.
So these are topic headings that are, in my mind, to avoid overlap with what the regional council has already conditioned that a district suite of conditions might cover. So, and I've used some of the headings out of the conditions that were circulated with the legal submissions, but the first one is reserves management. The second heading was coastal protection structure design and placement. Noise and vibration. And this is one I wasn't sure of, but I'll just give it to you for your consideration. I've called it long-term public access. The next one is transport-related issues, namely use of public roads and access to the site. Signage with respect to district council matters. There'll be a regional council sign already because they have a signage condition, but I suppose we should have should consent be granted to have a district council sign as well, saying who the contact details are at the district. Accidental discovery protocol, that's outside. Well, it's not totally outside the ambit of the regional consent, but it's probably useful to include here. Just a heading I called general maintenance. And again, given if the intent is to vest the structure with the district council, I think that needs to be covered. And then finally, something that we'll need to turn our minds to, and you've just discussed, is consent duration. And then the obvious review conditions, etc., the administrative conditions. So that's just my preliminary thoughts on what it might look like if we're to avoid overlap.
Thank you, sir.
But I look forward to hearing from you at a later stage on that. Not today, but as part of the reply.
Yep. Thank you.
Can I just check if we have any more questions, Mr. Faithful? No. Right, thanks, Mr. Faithful. So, Mr. Slyfield, anything you want to say at this stage before we turn to hear from some submitters?
No, thank you, sir. Happy to hear from submitters, and we'll come back to you in reply.
Yeah, now just in terms of the reply, certainly my experience has been in recent years that applicants prefer to either give a short verbal reply at the end of proceedings and then follow up in writing, or to not give a verbal reply at all and just do a full reply in writing so that things can be considered and properly and documented for our benefit. Have you given any thoughts to how you might want to run the reply tomorrow?
We have, and I think it might be a little premature to describe it being one or other or some alternative of those until we have a bit of a better handle on where the council is sitting.
Mm-hmm.
So at some point, obviously, we can come back to that and discuss it. But I have a similar experience to you, sir, in terms of the trends of it being something that doesn't always happen in the hearing anymore. But I think that's a matter that may be better judged once we have a bit of a better handle on what the position of the council officers is, and that may be something that we can discuss a little bit in advance of tomorrow directly with Ms. Hill and with Mr. Hudson to see how we're tracking.
Yeah. Well, to assist you, our strong preference is for a written reply, regardless of whether you choose to do a verbal tomorrow.
Okay.
The reasons for that is that we can then, if you do a verbal, we can listen to you and we're not busily writing notes for ourselves. And if there's a written reply, then it's properly considered, it's in writing, and we have it for our records. And I anticipate there'll be some work to do on conditions for our consideration. So strong preference for a written reply, and leave it in your hands if you wish to do a verbal as well.
Thank you.
Of course, it's up to you to decide what to do.
I'll take on board that guidance.
Thank you. Turn my mic off. What I do now. Thank you. So we're hearing from submitters, and I understand first two submitters are coming to us on Zoom. And Nancy, is it Ms. Coombs first or Mr. Gillespie first?
Be Robert. I can't see his name.
We're a little bit early
on here, and it doesn't look like Pip is ready. Hold on. But Keith is ready.
Pardon?
Keith is. Oh, hold on. Yeah. It doesn't look like they're ready to go, but Keith is ready.
It's Mr. Hay, Caddy Waihi Beach Residents and Ratepayers Association. You happy to go now? And there's a table for you there, and someone's going to come along and help you and show you how to work the microphones, etc. Oh, no, that's quite all right. Now, Mr. Hay, thank you very much for your submission and also for going to the trouble of preparing your written evidence, which was pre-circulated. We do appreciate that. We've read that, so you don't need to read that out loud to us, but we're very interested to hear anything that you wish to say to us by way of summary or key points, and then we'll see if we have questions for you.
Okay, thank you. This is the submission of the Cadicat Waihi Beach Residents Ratepayers Association. My name's Keith Hay. I'm the current chairman. I would first like to comment on some of the statements made by Mr. Boyd and his supplementary evidence. We didn't query the number of times the creek has been dredged. What we queried was the misleading information about how often it was dredged. In the application and the Section 42 report, and in Davis Coastal Consultants' evidence. And it is our understanding that Western Bay Plenty District Council decide when the creek needs to be dredged, not Regional Council. The consent is held by District Council, and it is they who are responsible for instructing the contractor where the sand should be put, not the Regional Council as stated by Mr. Boyd. Perhaps the trailers do not have to be registered, but Mr. Boyd has not addressed whether they pay road user charges. These tractor trailer units do much more damage to our roads than conventional vehicles. The minutes of Council's projects and monitoring committee meeting on 31 October 23 record that the resolution to support this proposal in principle was subject to an agreement between the applicant and Council on operational costs and responsibilities. We have asked Council 3 times for a copy of this agreement and have been refused 3 times. Each time we have been given a different reason. The first time, February the 5th, quote, Council in its capacity as a landowner has not entered into an agreement at this point in time. 11th of April 25, quote, this information has been withheld from public release under Section 7H of the LGOIMA to enable us to carry out, without prejudice or disadvantage, commercial activities. 30th of May this year, quote, and this is just part of the reason, providing a copy of the draft agreement to you would place Council in breach of obligations of confidence owed to GIPS and would also fail to maintain the legal professional privilege in the draft agreement owed to GIPS by circulating it to a third party. We do not understand how the Commission can make a decision on this application while this agreement remains a secret. We are concerned that the reason for the secrecy might be because one of the members of GIPS who took part in the pre-app meeting is a director of the local government finance agency. Slide 1 is a Google Earth imagery of Waihi Beach. You've seen all these, have you, sir? Yeah. Okay. Page 7 of the application document states that 3 Mile Creek is periodically dredged by Western Bay Plenty District Council in accordance with the relevant reserve management plan. Dredging typically occurs monthly and sand is deposited immediately south of the 3 Mile Creek, seaward of the dunes. The reserve management plan does not mention dredging or any other excavation work. The dredging is carried out under a resource consent granted to Western Bay Plenty District Council. Dredging is done on an as required basis, as illustrated by this data supplied by Council on 13 February 25. 2020, 10 times, 21, 4 times, 22, 9 times, none in 2023, and 4 times in 2024. And dredging is not allowed from 1st of August to 31 October, which partly coincides with the period that the proposal is to take place. Dredging is not carried out typically monthly, as stated in the application, and the claim by Davis Coastal Consultants that the creek still requires groins and manual cleaning, typically monthly and after storm events to maintain flow, is also wrong. It hasn't been challenged by staff, and neither is the dredging exercised by Western Bay Plenty every 1 or 2 months, as stated in the Section 42 report. Can we go to slide 3? Slide 3 is the map from the dredging consent document that shows where the dredged material should be put. And you can see that it's meant to be put in front of numbers 9, 11, and 13 Glen Isla Place. Condition 6.2 of the consent requires that sand material excavated under this consent shall be deposited in the active mid to upper beach system and shall not be removed from the coastal marine area. Slide 4A shows sand excavated but placed inside the groins. My experience is that the dredged material is not normally deposited immediately south of 3 Mile Creek, but dumped on the creek banks from where it is washed back into the creek. It either accumulates on the stream bed or is washed out to sea. The sand that is not washed out to sea starts to build up in the stream bed and eventually has to be dug out again. There is no incentive for the contractor to place the sand against the dunes. Slide 4B. Usually the excavation is only large enough to allow the build-up water to escape. This is typical of the way the contractor clears the mouth of 3 Mile Creek. A trench is dug along the creek just wide enough to restore the flow. Slide 5 shows compliance officers from both Western Bay of Plenty District Council and Bay of Plenty Regional Council on the job in 2020. In 2020, Veolia were contracted to supervise operations under this consent. We were advised by council that the staff of both Veolia and beach contractors were aware of the conditions of this consent. So there were 4 organisations that knew the conditions of the consent, but not one of them appears to have made any effort to ensure compliance in this case and in many others. We contend that failure to comply with the conditions of this consent has been responsible for most of the degradation of the dunes adjacent to the mouth of 3 Mile Creek. If the conditions of the dredging consent were enforced, the dunes would be replenished regularly. If the creek was not there, this sand would continue to move along the beach and some of it would be added to the dunes. The sand that accumulates in the creek is beach sand. It belongs on the beach or in the dunes. Large quantities should not be allowed to accumulate in the creek or be washed out to sea, nor should it be trucked away. Slide 6 shows a truck being loaded with sand on 19 September 2020. Over 100 cubic meters of sand was dug out of the creek that day. There are other claims in the DCC report that are of questionable validity, which have not been queried by either council. For example, it is hypothesized that 3 Mile Creek represents a reasonable sediment source to the beach system, which has assisted as in input to the sediment budget at the site. We are not aware of anywhere in the that's end quote. We are not aware of anywhere in the catchment of 3 Mile Creek that would be supplying a significant amount of sediment to this creek. The source of the sediment is extremely important. So why have staff accepted this hypothesis without question? And also, quote, since construction of the groins, sand has tended to accumulate on the southern side of the southern groin, indicative of a net northerly longshore transport of sediment, at least in the period since construction was undertaken in 2011. This, unquote, this is just as likely to be because the southern groin extends further out across the beach, or because on the very rare occasions when dredged material is put outside the groins, it is placed south of the creek because that's the easiest place to put it.
So, Mr. Hay, just as you're proceeding through your presentation, you don't need to read the stuff in quotes. We've read the statement. So the stuff in italics and in quotes, we're happy to take that as read, but we're happy to hear your comments on it.
Okay. Transport impacts. It appears that the applicant intends to use tractor-trailer units to cart rocks from the quarry to the site of the revetment. While the use of these units means that there may be less vibration from dumping rocks that cause structural damage to houses in the past, there are other problems with the use of tractors. Slide 8, please. The contractor that the applicant proposes to do the work has used these tractor-trailer units on other contracts at Waihi Beach, usually carting rock from the quarry or spoil to the quarry. These units with big cleated tires damage the seal on the roads. The ones we have observed have not displayed registration plates, and so their owner does not pay road user charges. The reference in the application to the use of road legal tractors appears to be a response to community concern about the use of unregistered vehicles around the beach. If this consent is granted, we ask that District Council includes a condition requiring all vehicles carting to or from the site to pay road user charges. Slide 9. This shows an overloaded truck on Wilson Road carting rock to a development site less than 1 kilometre south of Glen Isla Place. When it was proposed that a large quantity of material would be carted from the Waihi Beach Quarry to a site south of the village several years ago, Council's consent specified a route for these trucks which avoided the village. The cartage contractor on this project ignored this condition until eventually Council served them with an abatement notice. The case went to court, the abatement notice was upheld, but the contractor continued to disregard the consent condition. The quantity to be carted for this proposal is less than the previous one, but we don't want more overloaded vehicles going through our shopping centre again. So I can just talk about vibration. For the AE states that there's a quote there. That statement is only partly true. Council does not have vibration standards, but vibration has been an issue in the district, and Council has been either unable or unwilling to manage it. We understand that at least one house on the creek side of Glen Isla Place previously suffered severe structural damage because of vibration from similar activities north of the creek to those proposed for south of the creek. Slide 10, please. We have some experience with Western Bay Plenty District Council when it comes to vibration damage. Council required the developer of a block at 8 to 10 Wilson Road to have a vibration monitor on site to protect Council's infrastructure. But when vibration from this development caused damage to neighbouring properties, Council compliance officers did not want to know about it. The affected neighbours had to take the contractor to court to get compensation. The vibration records for this project show that although this machine could operate for long periods without exceeding vibration limits, it was capable of exceeding the limit by up to 60 times the allowed peak particle velocity. This was a self-imposed limit. So we don't accept that the limited test work carried out by the applicant's consultant proves there will not be damage to property if this proposal goes ahead. The andesite rock from the beach quarry is not of good quality because of the number of xenoliths of weaker rock it contains. The applicant is going to use weathered rock, so when the revetment is uncovered, the rocks will look natural. There are 3 problems with this. No rock is going to look natural in the sand dunes. Weathered rock will break down more quickly than fresh rock, and people are already complaining about all the bits of rock on the beaches that are backed, the part of the beach that is backed by revetments. And having weathered rocks indicates the applicant expects the revetment to be exposed on a regular basis. We cannot find any reference to the quantity of rock that will be required, but our calculations are that more than 3,000 cubic metres of rock will have to be imported. If natural processes are anticipated to quickly restore sand, as in that quote, if natural processes are anticipated to quickly restore sand and dune vegetation to the revetment, it might be anticipated that these same processes will add sand to the dunes even if the revetment was not in place. There is another consent that's appropriate to this area. We contend that if the conditions of 2 current resource consents were enforced, it would ensure that that the dunes south of 3 Mile Creek would regularly get additional sand. Consent 62913 granted to Western Bay of Plenty in 2008 expires 2032, allows the council to carry out large-scale earthworks in the erosion hazard zone. There's an advice note there that I won't read out. Consent RM 190613 granted to Western Bay of Plenty in December 2019 for coastal dredging requires that sand material excavated under this consent shall be deposited in the active mid to upper beach system and shall not be removed from the coastal marine area. The consent applies to 3 Mile Creek as well as the other 3 creeks at Waihi Beach. As mentioned above, the condition requiring sand excavated from the creeks to be placed in the active mid to upper beach system is more honoured in the breach than in the observance. If it was honoured more often, there would probably be no need for this consent. We think it is more important that council ensures compliance with existing consents rather than issuing new ones. And I might refer to a quote from one of the applicant's consultants, that every metre makes a difference. There's thousands of cubic metres of sand wasted that could be used in the dunes. We think there are too many unknowns with this proposal. And if the conditions of resource consent 190613 had been enforced, and we contend that the dunes to the south of 3 Mile Creek would have been, we contend that the dunes to the south of 3 Mile Creek would have been replenished with sand often enough that the dunes would be much more resilient than they are now. Furthermore, if the conditions of RM 190613 are enforced in future, there will be no need of hard protection structures which interfere with natural coastal processes. We request that you reject this application. Thank you.
Thank you, Mr. Hale. Just see if we have questions for you.
Thank you. Thank you for your presentation. And thanks for coming in today to present your submission to us in person. I just have a question in regards to the dredge material. So is it your contention that if the dredge material was deposited how it's supposed to from a consenting point of view, that the works the applicant has proposed wouldn't be required? That's your contention?
I think there's a very good chance that if those 2 consents were complied with, the earlier one allows push-ups. So with the combination of the sand that's dredged from the creek being placed against the dunes and push-ups, I think, yes.
And just another question, and I can't recall how long the existing groins have been in place, and you might be able to tell me. But if those groins weren't there, and material was removed from the creek. Would that deliver a similar outcome, do you think?
Sorry, I didn't quite I'm having trouble hearing you too.
No, that's fine. The existing groins, how long have the existing groins been in place?
I think they were placed in 2011, but I'm not absolutely sure.
That sounds familiar. Sorry, it had trouble kind of reflecting on that. And so if the council were to continue to dredge 3 Mile Creek and place sand into the consented areas, do you think that would address the issue of erosion from your perspective?
I think there's a very good chance that it would supply enough sand to the dunes south of the creek, at least, that this rock wall wouldn't be required.
Thank you.
Hi, Mr. Hay. I just have one question for you. With the proposal as it stands at the moment, we're looking at essentially a range of sites between 1.5 meters or 5 meters from the boundary. Do you, if the wall was constructed and it was closer, so at the 1.5, does that change your view at all in terms of whether this could go ahead?
No.
And when you visualize the structure, are you thinking of the one on the other side? Are you expecting that that's what you'll be seeing at the beach? Sorry, when I say the other side, I mean the seawall to the north of 3 Mile Creek.
There is a seawall north of 3 Mile Creek, but there's a gap between the creek and where that seawall starts.
Yes, so my question is, are you envisaging that that's what this proposed seawall might look like?
Well, yes, it would if the sand was eroded from in front of it.
Okay.
But I understand that it's meant to be covered with sand, yeah.
And from the simulation we saw, I mean, I guess it depends on the rate of erosion and the passage of time, but it looks like it won't be as imposing, I guess, as that structure.
Perhaps not.
Okay, thank you.
And Mr. Hay, you talked to us at some length about your concern with the vehicles and potential damage to the road. The applicants volunteered a condition whereby any damage to the road associated with this application has to be repaired and made good by the applicant. Does that satisfy your concerns? So if they damage the road, they're going to have to fix it.
No, I acknowledge that, but then you get into the argument of what caused the damage. Was it just general rear and tear, or was it the contractor's vehicles? We've got a road, Waihi Beach Road, that's since the summer of 2017, parts of it have been resealed 4 times, some of them. And at the moment, there's several kilometres with only about half the chip left on it from last summer's work. So we have real problems at Waihi Beach with damage to roads.
Just by way of interest, that's not a problem that's unique to Waihi Beach. The problem is that we don't make bitumen in New Zealand anymore because we closed down the New Zealand refinery, so we have to import it from overseas, and it's substandard and the stones don't stick to it properly. So it's a problem all around New Zealand, not just Waihi Beach. All right, thank you very much for that. Thanks for your written material and for talking to us today. I don't have any further questions for you. Thank you.
Thank you.
So I think we're going to hear from a couple of submitters on Zoom now. Nancy, are we hearing from Mr. Gillespie first or Ms. Coombs first? So Mr. Gillespie.
Just checking you can hear me, okay?
Yes, Mr. Gillespie, we can see you and hear you. Can you see us and hear us, or hear us anyway?
Yes, I can hear you clearly. Thank you very much.
All right, thank you. look forward to hearing what you're going to talk to us about this afternoon.
My name's Robert Gillespie. All right. I'm a property owner of probably the nearest coastal property to the Glen Isla Place area. All right. I own 2 sections at 87 Seaforth Road, which are the nearest properties to the other side of 3 Mile Creek to Glen Isla Place. Just as a bit of background, I have a degree in maths and physics. I'm the son of an architect who designed the property we have at Waihi Beach, and I own a number of coastal properties around New Zealand, which come into some of my knowledge of what's going on. All right. I've been coming to Waihi Beach since before I was born. My mum washed the nappies in 3 Mile Creek, she tells me, when I was a child. All right. Now, the points I want to cover today really are the risks of putting more rock walls and so on the beach, to the beach itself and the environment. All right. My mum keeps reminding me each time she comes to Waihi Beach, and she's just about to turn 100, so she's probably the longest living person with knowledge of the beach and its contours and how the sand dunes move. We'll be staying there at Christmas, and then she'll give me a hard time about the damage to the beach with the rocks and the rock walls. You know, the beach in my childhood was a pristine beach scattered with shells and driftwood. Now it's a beach which has varying levels of stones and pebbles and bits of debris associated with attempts at controlling the sea that have been put there, many of which I collect and happen to make up some of my garden framings and stuff of the various things of which were washed up, especially the stuff in front of Glen Isla Place, where when it was originally put in as a subdivision, the walls got washed away. All right. The continued craziness of trying to control the sea's behavior by rock walls is shown to have not worked. It'll change the natural contour of and behavior of the beach, and even the continued digging out and the groins associated with 3 Mile Creek are a major contributor to the erosion occurring in the area. For the last 70 odd years, my family have owned the property, and we've continued to put plantings and so on to protect the beach from erosion, of which as a child I was used to in a big storm, and actually the sea coming up and washing underneath the house that I have on Seaforth Road, which doesn't occur anymore and hasn't occurred for 40 odd years. The sea, the sand dunes have come and gone, and that's the natural way of things in terms of the sea. And really, I'm concerned about another wall being put in, and it's been acknowledged by some of your expert witnesses that there will be effects at either end of the wall, because when it hits some sort of barrier that's there, then there's going to be an effect, which one of those effects will be on my side, which is the northern side, and the other effect will be the southern side, of which it's really an unknown what level of effect there'll be. All right. Now I see, I have commented, you've got my written submission, so I wasn't going to read through it as I could, but in terms of, I see Dr. Bull didn't mention in her rebuttal to comments anything about how long it actually takes for regrowth. It's all well and good saying we'll replant where the works have been done and where the wall is buried, but in fact it takes a considerable amount of time for what growth you're going to destroy to actually come back. And I've got personal experience of having spent the last 50 years really trying to grow plants on the sea frontage, which I've got. My big concern with this whole proposal, though, is really the use of public land. Right? The proposal is to use public land without any benefit to the general public. The only benefit is to the 7 individual property owners and to leave the ratepayers with an unknown potential ongoing risk. My question to you, is that fair and reasonable? And I suggest not. Right. Then we have the rock walls claimed to be buried with sand, and then we hear, oh, it'll be exposed at various times and so on and so forth. Really there's a whole lot of great unknowns, and yet it's acknowledged that if you move it further back and you actually put it on the property owner's properties. So if I want to build a retaining wall on any of my other properties, I build it on my property. I don't expect to build it on someone else's land. All right. And, we have the opportunity for these owners to build it on their own properties, at the frontage of their properties. And they will then be reduced in terms of the exposure of that rock wall if we're going to put in such a thing as a retaining wall. The likelihood of its exposure, instead of being 35 years, might be 150 years before it gets exposed if global warming continues as it is. All right. Now, I use some public land in Wellington for one of my Wellington properties, and I pay a rental to the council for the use of that land, and it's really for similar use such as we've got here, and I pay a rental fee. And I'm responsible for the maintenance of it. So anything that goes on. This proposal appears to be, we'll do the capital expenditure and then we'll leave you to wear the ongoing issues. And the liability could be quite astronomical in terms of to the council. Why in the world would the council undertake that liability? Capital expenditure is easy. Ongoing maintenance is the costly bit with most things. So I suggest that there's no justification at all for the use of public land for this purpose to protect 7 property owners and yet give the liabilities of the whole of Western Bay Council ratepayers. Now, I'm just flabbergasted that the owners even have the gall to ask for such an application. All right, I purchased my property well aware of the risks of it being built on the sand. I put in the quote from the Bible because that comes always to mind to me, is he who builds his house on the sand is at risk, and in basic terms is an idiot if they don't take that risk into account and aware of it. All the owners in Glen Isla Place have bought well since it was known that there was a risk in that area. And the Glen Island subdivision sat vacant for a number of years with only one house on it because the previous Hanimuri County Council recognised that it was a risk and didn't want a whole lot of houses in an area which was high risk. And now we're just going to take that risk on as a council. You've got to be mad as meat axes. All right. I'm very much aware of it and the honour of being able to, have access directly to the beach, be close to the beach. But I've made a hell of a lot of effort and forfeited my lovely sea views and stuff to make sure that I've got good growth of putakawa trees, large Norfolk pines and other things to protect that property as much as I can without doing any damage to the beach itself. It appears very much an application which is totally geared towards a small group of people, talking of a benefit to the public of being able to walk along the top of the wall or whatever. That's just ridiculous. The benefit's insignificant versus the benefit to the individual owners. All right. We've really got to say, if you want to do this thing, you've got to do it on your own land. You've got the land in front of them. And the poor sod who's put their swimming pool on the very edge of their property, well, hard luck. You can remove it and move your swimming pool to somewhere else. My really closing comment is this application appears to be for the benefit of a few at the expense of the majority of Western Bay of plenty ratepayers. the Department of Conservation, like me, have agreed that, you know, it should be built on the owner's properties. You know, if they want to build it, that's where they need to apply for consent. Then it becomes very clear whose ownership is and where it sits and where liability sits. I'd like to see the owners try and get insurance for building a retaining wall in the position where they're planning to build it. Very unlikely that anyone's going to provide them with insurance for it. And I do question the council in the last comment, really, does the approval of such use of public land create a precedence for the future for other applications? I'm really totally against this wall being positioned where it is, and really I regard it as undesirable to put any more rocks and so on the beach at all. But if you're going to do it, then you've got to do it on your own land, and you've got to do all the consents and stuff associated with doing development on your own property. That's really my set of comments for today.
Thank you, Mr. Gillespie. That's very clearly put. I'll see if we have questions for you. Questions? No? Do you have questions? No, Ms. Gillespie, it appears we don't have any questions for you. That's a compliment to the clarity. That's a compliment regarding the clarity of your presentation to us. So thank you very much.
Well, if you do ever want to know more about Waihi Beach and the beach behaviour, you know, my mum's still alive and she's got all her marbles, so she'd be more than happy to add comments. Thank you for the time.
Thank you. Now, I think the next submitter we're going to hear from this afternoon is Pippa Coombs.
Kia ora koutou, can you hear me?
Yes, we can. We can hear you and see you. Can you hear us?
I can hear you, yes, indeed.
Well, thank you very much. Sorry, just before you start, thank you very much for your submission and your written material, which is extremely comprehensive. So you're probably pleased to know we don't need you to read that all out loud to us, but we're looking forward to hearing you summarise your key points and outline your key concerns for us, please.
Yes, I just wish to thank the District Council for the exceptional ease in which this hearing has been managed, and particularly Nancy Butler. And I wish to thank you as the Commissioners for your valuable time and giving us the ability to be able to talk to our original submissions. It's very much appreciated. I was going to speak with regards to my submission first, but I've been given delegated authority to speak on behalf of the Right Honourable Helen Clark and her father, George Clark. I just wouldn't mind just quickly providing a couple of paragraphs from them, if that's okay, first off.
If that's fine, thank you.
Okay. George Clark is 103, so he's just pipped Robert's mother to the post with regards to his knowledge of the beach. He's been coming here in nappies as well. He's unable to attend today and sends his apologies. He's housebound now, and unfortunately Helen is currently on international business and provides her apologies as well for non-attendance. I did, however, visit George yesterday, as I do at least twice a week, to keep him in the loop and about the conservation efforts we have here at Waihi Beach. The doctoral's only been one of them. He's an avid conservationist and he wanted this to be relayed to you. And a Waihi Beach resident since the 80s, but as I've said, he's been coming to the beach since a wee nipper, really. He's seen a vast change to the beach and the damage due to obviously climate change as part of that recent years, and also the rock wall structures that have displaced the sand along the beach. He wishes the Commission as well with their hard decision making and hopes that there will be a right and just outcome to the hearing and consent process. The key points they'd like to read from their submission, and I'll just keep this really short because I appreciate you've read their submission, is a conflict with policy and legislation, which other people will be speaking to. the high ecological risk, particularly to the northern New Zealand dotterels. International and New Zealand case studies showing long-term negative impact of seawalls, and soft solutions such as dune restoration and sand pushing have been proven to be effective locally, particularly along the Coromandel and further along the beach southerly at Waihi Beach, and sending a negative precedent for the beach, allowing such walls risk triggering further seawall developments. However, if this was built on their own land, then this is a different scenario entirely. Over the last 10 years, there's been no evidence of dune restoration or coast care collaboration at the affected Glen Isla section. There's evidence of ongoing dune degradation from waste dumping, and the dune system at Glen Isla Place, and that's particularly number 12, has been dismantled and a gateway has been put in, and it was noted by Helen Clark on the 2nd of June 2025. I would like to also put in there that this application appears to be for the benefit of very few at the expense of a majority of Waihi Beach, ratepayers and our natural environs. The request is to reject the present Rockwall proposal and instead either adopt a sustainable, environmentally responsible option. And if the owners believe that the way to protect their properties is the installation of a rock wall, then the suggestion is that they apply for the same structure but on their own land, as all the properties have significant vacant frontage. Lastly, they'd like to state that my father and I would also like to support the submission of myself here now on behalf of Dotwatch, which I'll go into. Obviously, I can't answer any questions on behalf of them, but Helen did message me literally about half an hour ago asking how it was going. So I just corroborated she was fine with me to go ahead. Okay.
Sure, I just might ask you one thing. When you were talking to George and Helen, did they indicate to you why they thought this would be an expense for the ratepayers, given that certainly my understanding is the applicants are going to pay for the construction costs and will also be liable financially for ongoing maintenance costs? So did the Clarks explain their concern to you at all?
So it wasn't mentioned the expense as in monetary expense, as in the expense of losing beach to the general public and the ratepayers. So not monetary expense, I suppose. Environmental expense, I suppose, would be the right way of putting it.
All right, well, thank you for that. So now if you'd like to speak to your own submission, that'd be great.
I've read many of the submissions against the structure and acknowledge the points of law will be addressed by detail by others with relevant policies and legislations which are outlined in my own submission. I would like to touch on these, but would leave the legal pathway to those best placed to pursue it instead of focus on a few key points of interest. I would like to say that you call it GIPS society members are all holiday home owners with limited involvement in our tight-knit community beyond the payment of rates. In contrast, our community-led groups do not have the wealth or deep pockets for these types of proceedings and nor abilities to fund expert witnesses. I'd like to point out that what we bring instead of decades of experience, local knowledge and a common sense approach, a deep commitment, a strong community conscience and an unwavering passion to protect the place we permanently all call home. It appears that this application benefits a few at the expense of the majority of Glen Isla Place residents and permanent residents of Waihi Beach and our flora and fauna, in particular our avifauna. While evidence focuses on the northern New Zealand dotterel, we have an increasing number of other shorebirds such as variable oyster catchers, which are coming here in abundance. So we have other other species as well, which I can't evidence, but we're hoping that we'll have breeding seasons this year with them. The document has been written with myself as the coordinator of DotWatch, and with Stuart Atwood, who is the shorebird ranger for the Bay of Plenty. He's employed by DOC, Bay Conservation Alliance, and the Regional Council. So we have knowledge there. We've been doing this for some time now. I joined the fight in 2020. I'd like to just point you to the photographs, just with regards to information that's come to light post submission. I've put in a supplementary evidence, and so's Andrew Fraser. So I visited 12 Glen Isla Place on the 2nd of February. As a guest. So we see here on the first photograph, are you able to see those photographs? Yeah. There's quite some significant dune from the sea here. And as I said, that on the 2nd of June, I got word from Helen Clark that the dune system had been dismantled in its entirety in front of 12 Glen Isla Place. If we can just move on to the next. So this is, unfortunately, we've only got side views. So if we pop on to the next one. All of this dune segment's been taken out in its entirety. There was probably about 2 or 3 meters there and a 2-foot drop onto the beach. If we that was taken on the 2nd of June when I found out about this. If we pop onto the next one slide. It's just a little bit further back so you can see the extent of this. And then the next slide. So this was further back. This was taken after the storms on the 30th of July this year. You need to study them, but there's really not much different. There's not much difference in the 2 photographs. And I would like to raise the point that Mr. Fraser has put in his evidence that there's been some erosion or disturbance seems to have occurred in the vicinity of the path to 12 Glen Isla Place. And referring to a phenomenon that DotWatch refers to in our brief evidence. There's been no erosional phenomenon. This is just purely at the expense of 12 Glen Isla Place and the new owners, Mr. and Mrs. Basson, and putting in a fence and a gate and a nice little walkway down to the beach. Now I see from Mr. Fraser's submissions at point 21 that Mr. and Mrs. Basson have been in touch with Coast Care already to re-establish some of the native planting that was removed from their land when the fence was installed. I mean, this is significant damage. So obviously, I went to Coast Care and asked them exactly that question. I received an email this morning at 6:43, which will be distributed to yourselves. Nancy Butler does have a copy of this. They have not received any contact from Mrs. Basson or Mr. Basson regarding the dune restoration or plantings, referring to 12 Glen Isla Place. And this is from Shiana Chadwick. My area that I look after is from the north end where the boat ramp is at the Surf Life Saving Club, right through to the end of Bowen Town, all mid, back and frontal dune systems. So I'd like to strike that from the supplementary evidence that Mr. Fraser's put in as being incorrect. I'd like to just very quickly touch on areas that I have put in my submission, and I appreciate you've read them, but these are areas that I feel are really quite important. And it was the District Council's process under the resolution put forward on the 31st of October 23. And there was limited consideration to New Zealand Coastal Policy Statement, Resource Management Act, and a lack of detail provided to the elected members. Shifting responsibility to the regional council rather than to the district council for making this decision. I've got concerns of procedural fairness. The elected members were not given sufficient information to make an informed decision. And I appreciate you've read Jim Dan's report as part of my submission, which is, great, because he's 40 years in the business. He's a very intelligent man. So there's a contradiction in approach here from the council to this actual resource consent, as they are trying to do the whole 10 kilometres as sand pushers. And I know you've asked for further information, or somebody's asked for further information with regards to how far this is on. And the existing obligations, so previous consents for seawalls require the District Council to investigate the best practicable option for long-term coastal management, something which I argue has been bypassed with this decision-making process with the council. And then the ecological significance, this is just what I would really like to touch on. I know I've got 20 minutes and I know I can talk, so apologies. I watched Dr. Lee's presentation earlier on today, and I note the nesting evidence provided by Dr. Lee in her submission has not come from our official records, neither that of DocWatch, Doc, or the BCA Shorebird Ranger. We've not been approached. This is circumstantial evidence given by Mrs. O'Sullivan, who used to be one of my volunteers. She was formerly a DocWatch member, trained by Dock and Bay Conservation Alliance and the Shorebird Ranger at Miranda Shorebird Centre. I've kept her out of my submission, original submission, and cut her out of photographs, but she's put herself to the fore now with regards to talking to Dr. Lee on the 11th of March 25. We haven't been approached by anybody. We've been there all along. We are extremely approachable with regards to discussing the doctoral, I suppose we'd probably call it how the whole beach comes together as one ecological area. We have 11 nesting sites at the beach, not the 2 that Dr. Lee spoke about. Okay, so we have dotterels nesting way back in the dunes. So she's very out of date with regards to her evidence. She's stating that the dotterels nest on sandy beaches in view, but no, we have dotterels from along the coast of the Bay of Plenty, nesting way back in the dune areas. They're having to adapt to massive building over their nesting grounds. I don't know if you've read in the newspaper, we've had dotterels 2 kilometres away from Island View nesting in cow fields, and this is where community comes into it. The farmer removed cows from 20 hectares of land to allow those dotterels to nest. When the birds have fledged, they come down to 3 Mile Creek and stay in the surrounding dune area south. So it's a significant area for all 11 breeding sites, for all fledged chicks to move to that area to feed at the mouth of 3 Mile Creek. We have an exceptional fledgling rate at Waihi Beach, and although this sounds terrible, 9.6% of eggs that hatch fledge. That's 9.6%. National average is 0.23 to 1%. So we're in a credible battle here. Over the last 5 years, we've really made a difference. We have a Tamariki Dot Watch team whose work has become a model of intergenerational kaitiakitanga. And we've had a book, we've been approached and had a book published with regards to the work and the mahi that they've done. And they are actually in that book, which is educational series. The 3 Mile Creek is essentially the only intact section of Waihi Beach where chicks can move to the intertidal zone to feed, but also be able to move back into the dunes. We have had nests there. We have had some unsuccessful nests, which Dr. Lee spoke of, and I'll confirm that those were 2 unsuccessful nests. We have had many other successful nests. Any disturbance to this habitat would directly undermine years of local goodwill and conservation investment since 2020. Believe that it would reverse hard game wins and fledgling results. Having looked to get legal precedent from across the world, not legal precedent for this type of build across the world, as well as in New Zealand, there are so many factors that could damage this area beyond its reasonable natural state. Any damage to this area would undo years of our community effort. And I could go on and I won't, because I think I've made my point. But thank you very much for listening. You can tell I'm quite passionate about it. And again, we don't have any issues with regards to the area being built on their own land, but there's a really great system in place. Once that's disturbed and planting, which takes years and years to establish, we can't foresee into the future what's going to happen with regards to the storms. We've seen hail and the 2 cyclones come in and destroy our beachfront. So it's a real worry.
Thank you for that. I'll see if we have questions.
Thank you. Thank you for your presentation to us today and all the information that you've supported or provided in support of your submission. Probably just one question from me, and that's in relation to the dotterels. Is it your concern that or focus is primarily on protecting habitat for dotterels?
We're primarily protection of habitat and not disturbing habitat, but this is the only piece of habitat that's left along the beach that is suitable for dotterels. So if you get on a RV, which not an RV, one of the surf club drive me up every year up the beach to check where we could potentially have dotterels nesting and feeding. That's it now. That's all we've got.
Thank you.
In terms of a longer term view, if the proposal was to go ahead and the dunes were completely re-established with native vegetation, once that had established, would that be an improvement for dotterel habitat in the long run?
That's quite subjective to answer, because we don't know what it's going to look like. We don't know whether or not those dunes are going to be blown away, because obviously the plants are not going to be established for some time. It takes a long time for a dune to re-establish itself. And also there's obviously disregard for environmental stewardship. So we're just worried that this may fall on the wayside. Even if terms and conditions are put in place by the district council, who's going to enforce those terms and conditions and manage those terms and conditions to ensure that the consent is being adhered to? The whole process is quite concerning.
just as an aside, my experience from Whangamata is the following Cyclone Gabrielle, they did push up and create new dunes,
Oh,
and
yes.
they planted
Yeah.
them quite successfully. And within a year, you wouldn't even know that there'd been erosion. So that's a success story in terms of natural revegetation of dunes.
Yep, and that could be achieved with sand pushers, etc. We've had 2 nests on sand pushers so far in the last 2 years. So yeah, quite interesting that sand pushers seem to be somewhere that they will look at to nest on.
Just you've raised a number of concerns about the district council's process in terms of providing preliminary approval for the wall to be located in the reserve. Just wanted to let you know that it's not something that falls within our jurisdiction to question or to revisit. We're not the council. We're an independent hearings panel, and our job is to assess the application that's been applied for based on the evidence presented in terms of its potential effects. So we're not going to revisit or question the council's internal processes regarding the reserve management and the use of that reserve. It's not our job. Yep. So a couple of questions. In your experience, have there been any dotterels nesting, in the vegetated parts of the reserve in front of the Glen Isla properties that fall within the proposed footprint of the wall? So it's the vegetated, sort of the non-Indigenous vegetated area that's where the wall is going to be located. Have dotterels nested in that part?
So what I can speak to there is that we've only just, in the last 18 months, found evidence that the dotterels are nesting in that similar vegetation. We haven't had confirmation that this has occurred at 3 Mile Creek. However, we weren't looking for it. And we have had a significant number of dotterels go AWOL, so 6 pairs that are nesting elsewhere. So they always come back to the same area year in, year out. So that's not to say that they haven't. But this year and the back end of last year, we ramped up the volunteer effort to try and establish, and this is where we found the other birds nesting within the dune systems. It's really difficult for volunteers with 10 kilometres of beach to focus on all the dune systems, but we certainly have now worked out a strategy where these will be covered in their entirety during this season. And they can breed up to 3 times, the dotterels, so it's really full on for 6 months trying to locate them.
Yeah. All right, but no evidence that you're aware of that that's occurred in this location today?
Not up in the back of the dune system, no.
Yeah. Now, have you managed to look at the conditions that the regional council has imposed on this proposal?
No, I've not seen those yet.
Okay, well, I can't ask you about that. All right, well, thank you very much for coming in this afternoon and for making your presentation to us and for answering our questions. We appreciate it.
Much appreciated for you taking the time to listen. Thank you.
You're welcome. Right, I think that brings us to the end of submitters that we're going to hear from today. Nancy, is that correct? Yes. All right, so just before we adjourn for the day, Mr. Slyfield, anything you'd like to say at this stage?
No, nothing from me. Thank you, sir.
Ms. Hill, anything you want to bring to our attention at this stage? All right, so we're adjourned and we will reconvene at 9 o'clock tomorrow where we continue to hear from some